All right, I will call this meeting of the Senate Public Safety and Security Committee to order. Will the Secretary please take the roll?
Senator Flores,
Present.
Senator Orenshaw,
Here.
Senator Pizzino, Senator Hansen, Senator Krasner, Senator Ellison, Chair Scheibel.
And I am here. Thank you so much. We have one bill to hear this afternoon. That is AB 4. We are looking at the second reprint, which is available in the back of the room, also available on Nellis. And I think at this point everybody knows how our hearing structure goes in here. We take the bill presenters first, we ask them questions, then we go to support, opposition, and neutral. In my committee, we ask that you all use your best judgment whether to testify in support, opposition, or neutral. Testify in support if you'd rather we press the green button on this bill. Testify in opposition if you'd rather we press the red button. Testify in neutral if you really do not care but you believe you have information that will help us make a decision. And with that being said, I will go ahead and open up the hearing on AB 4 and invite our presenters to the front of the room. And I do understand that we have a series of presenters, and with only 2 chairs down here, you guys will have to rotate in and out, and we appreciate you working with us to make that possible. So please go ahead when you're ready.
Good afternoon, Chair Scheibel and members of the committee. My name is Chris Hicks, C-H-R-I-S-H-I-C-K-S. I'm the Washoe County District Attorney. I'm also the president of the Nevada District Attorneys Association. Nevadans deserve to feel safe. Safe in their homes, safe in their neighborhoods, on our roadways, in their schools, and victims of crime deserve to be protected and supported. Governor Lombardo's Safe Streets and Neighborhood Act focuses on those very ideals. It is a reasonable, common sense criminal justice reform that is designed to protect our communities by addressing serious and repeat criminal behavior, by prioritizing accountability, victim protection, and public safety. AB 4 offers a balanced reform that reflects the value of Nevadans across the political spectrum. It strengthens protections for victims and assures accountability for offenders in several important ways. First, it modernizes stalking laws to include harassment and intimidation carried out through social media. And it expands the definition of domestic violence to include attempt and kidnapping offenses. And I can tell you in my 24-year career as a prosecutor, more times than not, I'm very comfortable to say kidnapping involves some kind of domestic relationship. Those domestic violence additions recognize the many forms control and abuse can take. The act protects vulnerable Nevadans by assuring those who abuse children or the elderly cannot have their convictions immediately sealed and later obtain positions of trust caring for those same populations. It targets smash and grab thefts, applies appropriate accountability to child pornography possession, and prioritizes victim restitution over court fines and fees. It also takes steps to reduce violence in our classrooms by requiring evaluations for students who harm educators. And it strengthens our DUI laws to better address the devastating impact of impaired driving. These targeted measures are meaningful steps toward building safer streets and stronger neighborhoods in our state. We are all here today because we work for the great citizens of the state of Nevada. And a measure this important deserves to be completed. I'm grateful to this committee that it is willing to take it up again. Today is an opportunity for all of us to finish that work and move forward with reforms that will strengthen public safety in every corner of our state. I respectfully request your support. I am now going to turn it over to Chief Deputy District Attorney Jennifer Noble and Lieutenant Jason Woodard, who are going to walk you through some more substantive parts of the bill. And so I will relinquish my seat to those presenters. I thank you very much for your time and consideration.
Sorry, that red light wasn't going on. Good afternoon, Chair Scheibel and members of the committee. Jennifer Noble, for the record, on behalf of the Nevada District Attorneys Association and the Washoe County District Attorney. Thank you for hearing this bill here this afternoon. I'm going to walk you through some of the substantive provisions of the bill. As he has been many times in Judiciary Committee, Lieutenant Jason Woodard has agreed to be here to help answer any questions you may have. So we're going to start with stalking. Nevada stalking laws should be strengthened and updated to better address how this crime occurs in the 21st century. Cyber stalking impacts the daily lives of victims and is just as invasive, threatening, and fear-inducing as in-person stalking. And the increased prevalence of digital communications and social media provide new tools for modern abusers. It's a free platform with a large audience for people to post threatening communications not sent directly to the victim. Under current law, the victim's family and household members are recognized as people who may be targeted as part of a stalker's course of conduct. Section 3, sub 1 of the second reprint expands this list of persons to people who the victim does not cohabitate with, but the victim has had or has had a dating relationship. Please note that in this reprint, we've also changed some language from the original bill pertaining to social media accounts. Section 311A1 defines accessing a social media account as utilizing the login credentials or personal information of a specified person in order to gain access to that user's account. Section 311I, and I believe Roman numerals 1 through 3, define social media. I'm sorry, my insulin monitor's going. 1 second. Apologies. Sections 311I 1 through 3 define social media communications to include private messaging on a social media platform or communication shared on a social media platform visible to other users. Now, we have amended this language after talking to stakeholders and looking at First Amendment concerns. So it includes a communication without limitation, a message or image that is made available or otherwise shared on a social media platform, which is visible to other users and is designed to defame, threaten, and or incite others to violence toward the victim, a family or household member, or a person with whom the victim has or has had a dating relationship. The bill also addresses domestic violence, and as you know, stalking is often part of a domestic abuser's efforts to control and terrorize the victim, in addition to other crimes we might not typically associate with that cycle. And our current statute provides a list of crimes that can constitute felony domestic violence when they're committed in the context of a domestic relationship. Section 13 of the bill expands the list of felonies that may constitute domestic violence to add kidnapping and attempt offenses to that list of included felonies. Bill also addresses the unit of prosecution issue that we see with child pornography, or what we now call child sexual assault material. In addition to addressing the important issues of domestic violence, it's trying to protect children more. In Castaneda versus State, the Nevada Supreme Court recognized the public policy goal of tying the punishment for possession of child pornography to the number of issues the defendant possesses. But it explained that under our current statutory construction, Nevada law only allows a single count to be charged, even if the defendant has numerous depictions of children being sexually abused. In Castaneda, the defendant possessed 19 such images, but could only be prosecuted for a single count. Our statute prohibiting this kind of conduct should reflect that each image of a child victim represents unspeakable trauma, ongoing trauma, and recognize that harm that happens each time an image is downloaded or shared. Section 4 of the bill amends our current statute to provide that a separate felony count may be charged for each child depicted in the images. The Act also seeks to ensure greater protections for children as well as the elderly by eliminating automatic sealing eligibility for those who abuse or exploit our most vulnerable Nevadans. Under current law, offenders charged with felony abuse, neglect, or exploitation of children or the elderly may access diversion, dismissal, and automatic sealing of their records. Sections 21 through 24 prohibit automatic sealing of these offenses, but the offenders may still enroll in specialty court programs and obtain deferment and dismissal, just without the automatic sealing component. They may still apply to get their records sealed through the normal sealing statutes and the abbreviated times that were established in 2019. The bill's victim-centered approach continues by prioritizing victim restitution. Following the passage of Marsy's Law, the Nevada Constitution requires that any payments collected from a criminal defendant be first applied to pay restitution to the victim. Sections 28 and 29 require that any money collected from the defendant be first used to satisfy restitution before it can be applied to court fines and fees. This is consistent with our Nevada Constitution's requirement that any payment collected from a criminal defendant be first applied to pay restitution to the victim. But there's also language in there that provides that when a person other than the defendant posts bail, those funds may not be used to satisfy restitution without prior notice and consent of that third party. The bill also addresses some issues we've been having especially in our rural jurisdictions with regard to pretrial release hearings, just logistics. In 2021, the legislature passed Assembly Bill 424, which mandated that all pretrial release hearings be held 48 hours after a person is taken into custody. During the 2023 session, Chair Scheibel's efforts resulted in additional funding for rural areas that were particularly struggling with this new requirement, which was very much appreciated. However, we do have some struggles still in the rurals, and Section 30 of the bill permits cross-deputization of city attorneys to appear at those hearings just for that limited purpose in counties with populations of 100,000 or more. Children, teachers, and school employees deserve a safe learning environment, and in 2023, there were 6,800 violent incidents in Clark County schools within a 7-month period. That same year, there were 7,400 violent incidents reported in Washoe County schools. Section 15 of the bill helps ensure that this unacceptable violence is adequately addressed by our system. It provides that when a child is taken into custody for battery on a teacher, school employee, or child welfare professional for the third time in 1 year, and that child has been previously offered services through informal probation, diversionary services, or court intervention, if a petition is filed, an evaluation needs to be conducted before the child returns to school. Now, it does give the courts discretion to order that the child remain in detention or released with an ankle monitor pending that evaluation, and there's a good reason for that. Bridget Duffy, who can't be here today, has shared that in her experience, these kids often run after an incident like this happens, so we want to make sure we can get the services to them while we still know their location, essentially, so that they can get back to school and they can get back to school safely. Section 7 of the bill addresses smash and grab theft. It provides that if a person causes property damage to a retail establishment during the commission of a theft offense, and the aggregate value of the property of the theft and the property value of the merchandise taken and the property damage is $750 or more, it is a Category C felony. Now, this is not targeted to address large-scale retail theft rings, that footage we see on the news of people flooding the Sephora store and stealing a bunch of stuff, or 20 people running into an Apple store. It's really targeted toward smaller businesses in general, and our organized retail theft statute, I would note, it requires that we show a series of thefts with an intent to resell the stolen merchandise, and depending on the evidence and the particular facts and circumstances of the case, that statute just doesn't quite fit. So this is a proactive measure to address thefts that involve deliberate damage to security measures that are being taken by these businesses who are doing what they can to try to protect their merchandise. It addresses specifically deliberate property damage, and it shows that Nevada is serious about deterring retail theft in all its forms. The next section I'll talk about is driving under the influence. In 2024, 412 people died as a result of deadly crashes on Nevada roads. That's an increase from 2023, which was 390 deaths. And the leading causes of the crashes were speeding and impaired driving. Now, sections 52 and 54 are just cleanup provisions regarding the applicability of per se marijuana to felony DUI. They do not establish a new DUI penalty or theory of criminal liability, but they clarify our language created by Assembly Bill 400 in 2021 that inadvertently omitted reference to some types of felony DUI, specifically DUI causing death or substantial bodily harm and vehicular homicide. Under current law, the per se does apply to these forms of DUI, but the current statutory construction could be much clearer. Sections 53 and 55 increase the penalty range for our most tragic DUI cases, DUI causing death. For people who have not been previously convicted of DUI, the sentencing range is 2 to 25 years. If the person has been previously convicted of DUI, the penalty range becomes 5 to 25 years. Sections 34, 37, 43, and 71 pertain to medication for opioid use disorder, or MOUD programming. The Department of Health and Human Services is responsible for ensuring the state and federal guidelines are followed in these programs and plays a central role in overseeing and coordinating statewide efforts related to substance abuse and prevention. Sections 31 to 33, 35, and 36 allow the Nevada Department of Corrections to establish an alternative correctional program. Director Zarenda is available here today to answer any questions you may have regarding those sections. Section 14 provides that a certificate of innocence and a provision of award in a wrongful death action is not a finding of certain wrongdoings in the investigation or prosecution and is not a finding that there was not probable cause related to the offense. Jason Frierson is available here today to elaborate further and answer any questions you may have. Sections 31, 37, and 43, I've addressed those already, I'm sorry. Section 1, 2, 9, 10, and 46 pertain to our resort corridor. And we have Virginia Valentine and Matt Griffin available to answer questions and explain those sections further. Section 58.2 to 58.7 pertains to methods used by our prison system to calculate sentencing credits afforded to certain offenders. And it's my understanding that Attorney General Aaron Ford's Chief of Staff, Teresa Benitez-Thompson, will be here to explain those sections. And with that, Lieutenant Woodard and I would be happy to answer any questions you may have for us.
Okay, so just to clarify, are you completed with the whole presentation, or will there be other presenters coming to present other sections and take questions?
Thank you for the question, Chair Scheibel. Jennifer Noble for the record. I believe specifically Virginia Valentine and Matt Griffin are here to explain those sections pertaining to our resort corridors. And I believe Teresa Benitez-Thompson would also like to briefly explain the language in that section.
So I think what I'll do, if it's okay with everybody, is we'll go ahead and take questions on the sections that you just did your overview of. We'll kind of break this into a couple of mini presentations and questions instead of doing all the presentations and then having to come back. So, and I think you did an excellent job. You were very clear about the sections that you were explaining with the section numbers. So I will open it up now for questions on the sections that Ms. Noble has discussed, and it looks like Senator Ellison has a question, so please go ahead.
Thank you, Madam Chair, and thank you for the presentation. You're going so fast at the beginning, I wasn't sure, but I thought it was 311I, and that was on the pictures and of predators, and children and sexual abuse and stuff. I think that was a number. But the question was, several years back, I thought what they did was they were trying to put in a bill, and I don't know if that fell into this or not because I haven't got to see the new section until just now. But they were some of the DAs were working trying to take, if you did 20 pictures on one child, it'd be 20 cases or 20. Is that right now, or am I wrong? Or because I remember talking to the DA and he said that they were going to put something in, to address that, so.
Jennifer Noble for the record. Thank you for the question, Senator Ellison. You're absolutely right. In a prior iteration of this bill, back when it was Senate Bill 457, we were looking at a per image charge, but as we know, sometimes there can be thousands of images, and it was a more practical approach to charge per child depicted in the images possessed or disseminated by an offender on a specific instance of possession. So the director of our Child Advocacy Center, who prosecutes these cases, has informed me that this is a good way to approach it, because typically offenders, when it's not related to a child that they're specifically abusing, will have pictures of several different children. So we're already taking the ability. I can give you an example. Let me give you an example. I think that'll help. In 2022, we had a defendant named James Cannell in Washoe County, and he was a registered sex offender. He had images of at least 3 different boys aged 10 to 12 years old, different depictions of them. Under our current statute, we could only prosecute him for 1 count of possession. With this change, we can prosecute him for 3 counts of possession of child sexual assault material. Does that help clarify?
Yes, it does. And then I've got one more, and that was on the marijuana under the DUI. When they legalized marijuana, some of them went crazy over it and just kept piling it on, which we lost a good officer, was killed during that time for over medicated by marijuana or whatever you call it. But is that address this in here by how much you can have in your system? And I apologize, madam. So I'm hoping I didn't take too much. Okay, thank you.
Thank you for the question, Jennifer Noble, for the record. So this doesn't change our current law, but under our current law, the per se amounts that have been in statute for quite a while pertain to DUI causing death or substantial bodily harm and other forms of felony DUI. So in the case that you're referencing, this doesn't change anything or make a less strict penalty. It's just clarifying language to sort of avoid some motion practice we've seen in some jurisdictions. Just kind of cleaning up the statutes there.
Thank you. Thank you, madam.
All right, other questions on these sections of the bill? I will go to Senator Pizzina next.
Thank you so much, Chair. And I think I'm the only one sitting on the committee now who was not here for the initial hearing, so I apologize. And I think this might have something in reference as well to what Senator Ellison was just asking. But in sections 52 and 54, it provides that the prohibition on a person driving or operating a vehicle or vessel with a specific amount of marijuana or metabolite in their blood applies to certain offensible punishment as a felony, I guess. So I guess my question is, was this not included under other controlled substances, or is this something that's new for marijuana?
Thank you for the question, Senator Pizzina. Jennifer Noble for the record. So this is not changing the law, it's cleaning up the provisions. Under our current law, the per se amounts for marijuana apply to felony DUI only, not to misdemeanor DUI. And so this change doesn't affect other controlled substances, doesn't make anything stricter, it's just clarifying language to clean up something from a prior session.
All right, I think Senator Orenshaw also has a question. Go ahead.
Thank you, Chair. Thank you for the presentation. My question has to do with Section 29 on page 35. I wonder if you could give me a little background as to, the genesis of that. And my concern is, with that section, if it passes into law, is that, let's say, what we often hear about, innocent people who cannot afford to post bond and then are less likely to go to trial, maybe take a negotiation or a plea bargain. And just my concern with Section 29 is, if, let's say, a relative, might be willing to post a bond for bail, and could this have a chilling effect if then there's the danger that it could go to restitution rather than not? I wonder if you could kind of give a little background on that.
Jennifer Noble for the record. Thank you for the question, Senator Orenshaw. Actually, changes and working with the chair that we made to this language would specifically inoculate against the concern that you're talking about. So if a relative, friend, somebody like that posts bail, that can't be used to satisfy restitution unless they consent to that, essentially, as a possibility. So language was added in there to protect against that very same scenario that you're talking about.
Thank you. Thank you, Chair.
Thank you. Other questions on these portions? I am going to ask legal to weigh in on one section. I want to make sure that we have a very clear record, and you did address it, but I want to get clarity from our legal counsel on the issue of sealing records for people who access diversion programs with those child abuse convictions. And so I guess before I turn it over to you, Mr. Wilkinson, I want to put my understanding on the record, and you can tell me if this is correct, that when somebody is facing a child abuse conviction, if this bill were to pass, they would still have the possibility of going through a non-diversionary system. They could be convicted, they could go to trial, they could have, they could go through motion practice. That's one possible route. And at the end of that route, if they do have a conviction, then they're subject to the regular sealing statute. The other option is they could go through diversion. And under the current statute, once you complete diversion, you automatically get your record, your case dismissed, and your record sealed. The change in this bill doesn't have to do with the first avenue, only has to do with the second avenue. And now it says that if you go through that deferral process and you complete the program per the existing statute, at the end of that program, you are no longer entitled to the additional benefit of dismissal of the case and sealing of the record. Instead, at the end of the deferral program, you kind of go back to the other possible route, and you are in the same position as somebody who was convicted at trial of child abuse in terms of your ability to seal your record after meeting the other statutory requirements. Can you, I know that was a long and convoluted question, but if you can just help us understand what the consequences would be of passing the bill in terms of sealing records for people with child abuse convictions.
Thank you, Chair. Bradley Wilkinson, Committee Counsel. Your description there was entirely accurate, and that is exactly how it would work. So there's not really much I could add to that. The only minor clarification I guess I would point out, which is not a change, as you said, the existing system doesn't allow sealing of child abuse of a sexual nature, and that's a sex offense, so it's excluded from being eligible for record sealing. But other than that, your summary was entirely accurate and correct.
Well, thank you for that, and thank you for clarifying. It looks like we have one more question for you. I will go back to Senator Pezzina.
Thank you so much, Chair, and thank you again for the presentation and answering my previous question. I was curious how many changes may have occurred between the legislation that was presented to this committee during session and what's being presented now in AB 4 as part of the crime bill and the sections that you just reviewed. How many modifications happened and maybe why, if so?
Jennifer Noble for the record. Senator Pezzina, I'm going to do my best to try to answer your question, and I might have some clarifying questions for you along the way if that's okay. The bill has had some provisions removed since that time based on concerns of stakeholders. There have been other provisions that have been changed. For example, the stalking portion that I was talking about in social media, there are First Amendment concerns, and so we changed that in terms of posting to areas of speech that are generally not protected by the First Amendment. That's one change. Another, let me go through this really quickly and see. We did, in the original version of the bill, there was, in addition to kidnapping, we had robbery as a felony that could constitute domestic violence. Based on input from the public defenders, the governor's office, and the public defenders and the DA's mulled that over and as a compromise, took robbery out. That's one change. There have been additions with regard to some of the provisions in the prison sort of area of things that the director could probably explain better for you. I'm trying to go back because there's been a lot of iterations of this bill, but at its core, it is still the same general bill. One important, point of compromise was to take out the provisions that were throughout the bill, and maybe one of the biggest changes was to take out provisions that put the felony theft threshold back to where it was prior to Assembly Bill 236. And those were removed throughout, negotiations, et cetera. And so that's why we have the smash and grab piece as sort of a compromise piece of legislation that still leaves what was established by AB 236 intact. There were provisions regarding habitual offenders and the habitual criminal enhancement that were also removed from the bill.
Thank you so much. It's been a long time since I read the bill from last session, so having read this one more recently, I was curious about what had changed and the stakeholder discussions that may have led to it, so thank you very much.
All right. I think that brings us to the conclusion of questions for now. Unless Vice Chair Flores has some questions. Yeah, of course. Go ahead.
Thank you, Madam Chair, and thank you for the presentation. I know that you've had an opportunity to work with stakeholders, and I appreciate the fact that that occurred in the other house. And I know Senator Pezzina is right in between us. I apologize. We're both leaning over a little bit, but thank you. No, Senator, I'm just kidding.
No, I'm also very short, Senator Flores. So.
No, you're good, Senator. You're fine. I was just curious to know, I know that you mentioned already on the record that you had an opportunity to work with the stakeholders, particularly the other side. And I know there's still a few amendments that they've sent over that I believe there isn't an agreement with. And I was just curious to know what the greatest concerns. I don't know if you have those in front of you either. So some of the proposed amendments from please continue.
I'm sorry, Chair Flores. It hasn't been that long a day, but I'm trying not to talk over you. So I don't have them in front of me, but if there's a general area, like subject matter of amendment you want to talk about.
Sure, and if you don't mind, I'm just reading off of some of the recommendations here. So one of the amendments, and it's listed as Amendment 1 in what they provided to the committee so that the members can follow along. It says modify the language in Section 7 of the bill to define smash and grab and other types of barriers, and then change the category of felony from a C to a D. And I don't know if you had any feedback on that specific request.
Thank you for the question, Vice Chair Flores. So I am aware of that proposed amendment. I know that there were discussions had between the public defenders and the governor's office with regard to that. Our take on this as the DAs is that the language changes in there were a little bit too narrow. For example, it would not encompass all security measures that people are trying to take to protect their merchandise, especially smaller businesses. It was limited, I believe, to barriers to theft that were also designed to display items. So it wouldn't cover, for example, a wire attached to a power tool or something, if you cut that, and the aggregate value of the power tool and the security wire was $750, something like that. So it was a bit too narrow in scope. And additionally, having made some pretty substantial changes in terms of theft, we were also opposed as the DAs to reducing it to a D felony.
And Madam Chair, if I may ask two follow-ups. Thank you, and I appreciate that. And I also just wanted to get on the record, there was a second amendment that was also proposed. And members, that is amendment number 2, where it says amend section 21 of the bill to allow people who have changed their lives and are eligible to seal the records, but also protect those in the community. And this is going to the central repository. And I think one of the things that they were trying to get at is, I understand that we want to protect certain individuals from having access to particular jobs where we're working with vulnerable populations, and that makes absolute sense. I think everybody in this building is in agreement with that. But I think they were trying to kind of find the hybrid model to that approach. So what they were proposing was a carve out in the ceiling of the law to allow child care and elder care employers to still be able to see the prior convictions in sealed records when they run background checks. So they were trying to get a little bit of both sides of that, and I don't know if you had an opportunity to review that, and if I could get some feedback on that, please.
Jennifer Noble for the record. Thank you again for the question, Vice Chair. So I was able to review that, and as you just stated, our purpose here is really to at least have some time period between conviction or deferment and dismissal, completion of a specialty court program for these specific offenses that pertain to vulnerable populations, and somebody being employed in the care of those folks. So I think, there are certain entities, right, that can access records with the criminal repository, like the Board of Nursing, for example. But I'm thinking about myself as a mother and about people across this country who might be hiring somebody to watch their children, to help care for their elder person in their home. Now, when records are sealed is sealed, and no one can see them unless they have special access. Otherwise, they're public information, and if you are a parent or someone who has a loved one who needs special care, you can access public records to check out and do what you can to see if this is a safe person to leave around your loved one. And so that proposed solution left me with concerns about people who are trying to fulfill those types of positions but are not part of, a licensed child care facility. They're not the director of that. They're not at the Board of Nursing, et cetera.
Nothing further. Thank you. Appreciate you.
All right. Now I think we have no further questions for you. I will allow members to ask questions of previous presenters if they come up in further portions of the bill, but at this time we will move on to our next set of presenters who will explain another portion of the bill, and then we will get to ask them questions about the portion that they describe for us. So please go ahead whenever you're ready. I'm not sure if you've testified in this room before. In order to turn on the microphone, there's a button on the table that kind of looks like a sticker. You have to press it.
Thank you very much, Chair Scheibel. My name is Virginia Valentine. I'm the president of the Nevada Resort Association. We are here today in strong support of AB 4. I'd like to take a moment to note, since the question's been asked, that this language in this bill as it relates to the tourism safety proposal is exactly the same language that was in the last version of SB 457 voted out of the Assembly last session. I'd like to thank the Governor for bringing this bill and the opportunity to appear before you today to present it. And I also want to thank the Culinary Union for working with us. To keep our employees and guests safe, our member security teams work hand in hand with law enforcement to prevent crime and to catch those committing crimes. However, despite all our collective best efforts, there remain those offenders who are not deterred and who continue to perpetrate crimes undaunted by the current penalties. Recidivism continues to be a significant problem in our tourism areas. I'd like to provide some context on the prevalence of trespassing and its application, as that may not be clear. Before trespass is issued by resort security, there has been a crime or some incident on private property that results in security asking the individual to leave. The best way to explain these increases in incidents seen by resort security after resort court might be explained by giving you some examples. Scenario 1, an individual starts a fight, security breaks it up, ask if anyone wants to press charges, or file a police report. If they don't, they want to go home, they don't want to have their names on a police report, there's no arrest. The instigator is then trespassed from the property. Scenario 2, an individual steals a purse. Resort security catches the individual on surveillance, they recover the purse, the owner has an early flight and doesn't want to stay around to file a police report or to be a witness. The perpetrator is then trespassed again from the property, and again, no arrest is made. Next scenario, an individual starts a toilet paper fire in the restroom. The fire is extinguished, minor property damage, no arrest is made. The individual is trespassed. In cases like these, the same individuals return to the property and either commit the same crime, additional crimes, or additional trespasses. Typically at a resort hotel, resort security will not take Metro's resources to have an arrest until at least the 10th trespass. They document the incident as required in Nevada law. If that individual returns again, they may be trespassed. Security is very judicious in its use of Metro resources. And again, they may be trespassed at least up to 10 times within a period of time. At that point, Metro may make an arrest. If Metro does not make an arrest at that time, that also does not appear in the crime data. If the district attorney charges the individual, they will appear before a judge. If they do not charge the person, that won't appear in the data. And after that, the individual may be charged with multiple crimes if they do. In many cases, those charges are reduced or pled down. And if the charging documents are complete, the judge will hear from counsel for the defendant, and the prosecutor makes a determination on a sentence, a suspended sentence, a diversion program, and hopefully an order out to discourage that individual from returning to the area where they committed the crime. And in that case, that would be the order out area. Multiple crimes have already occurred, though, that will not be reflected in either Metro's data or the order out data. The number of cases seen by the court pales in comparison to what hotel security sees. So as you can see from these examples, right now, data is not consistent across the justice system, and in a lot of cases, not even available. Different pieces of data are being reported, but they do not tell the entire story. During the resort court's operation, resort security reported a decrease in the number of repeat offenders they saw returning to their properties. This bill is a tool to deter repeat offenders, and resort security teams did see a meaningful reduction while the court was operating. The order out quarters in the resort court had a profound impact on recidivism rate. During the nearly 18 months the court was in operation, violent crime, property crime, trespassing in the resort court were all down double-digit percentages. If you are not aware, the resort court had a process of ensuring the same judge, prosecutor, and public defender were involved in a defendant's case. This was to be sure they were all familiar with the defendant's history and also their needs. This perspective is vital to ensuring an effective order out and appropriately sentencing to stop this continued behavior. While there have been limited comprehensive data available on the resort court and order out offenses, what has been publicly reported clearly shows its effectiveness in preventing repeat offenders. And with that, I will turn it over to Matt Griffin to walk you through the sections of the bill that implement these tourism and employee safety provisions.
Good afternoon, Madam Chair and members of the committee. Thank you for having me before the committee today. My name is Matt Griffin, Griffin. I'm here today on behalf of Nevada Resort Association. And what I'm going to do is offer a summary of the provisions of this bill that relate to what Ms. Valentine was discussing. Those provisions, and I'm going to take them out of order, are Section 46, Section 9, Section 10, and Sections 1 and 2. I'm going to start with Section 46 because that has a lot of the issues that I suspect there may be questions out, or at least explains the majority of the content that we're seeking today. But before I get into any of that, I want to also note in kind of piggybacking off of Ms. Valentine's comment, this bill is what came out of the Assembly last session. There has been one, I think, important event between that time and this, which is in April 9th of this year, the Clark County District Court had opportunity to evaluate the constitutionality of what are commonly called order outs, prohibitions from entering the resort corridor. And in that decision, Judge Levitt in Clark County District Court ruled two things that I think are relevant to today's discussion. Number one is that drawing the boundaries of an order out and even the misdemeanor authority of a county commission was affirmed by the district court as being a constitutional authority that a county commission can promulgate ordinances in that respect. And I think number two, probably most importantly, is that the prohibition of entering out a defined area that the county defines is not a violation of the First Amendment. And Judge Levitt's opinion kind of had a pretty good summary of that. So I mentioned all of that because that, between the last time we spoke and today, excuse me, that is the only substantive change that I can think of, but it is relevant to this committee's consideration today. So starting first with Section 46, and as I flip through this, I'm happy to slow down and make sure everybody kind of follows along because it is out of order. Section 46, under the county commission's authority to regulate criminal misdemeanors in their jurisdiction, subsection 1 of 46 provides that counties of 700,000 residents or more, so we're talking about Clark County, must establish what is being called to as an order out corridor or a resort corridor. Those are kind of interchangeable phrases. Pursuant to subsection 2 of that section, these corridors do not have to be contiguous, and there can be more than one order out corridor. But the key to all of this is the order out corridors should focus on those areas where there is a heightened risk to public safety because of the volume of tourists and employees that work there and the threat that it poses to their safety as well as to the state's economic viability. Also under subsection 2, the map of that corridor, once the county promulgates the map, must be displayed on the county's website for all to see of what that corridor looks like. I would say in some of what we're talking to, and I'll reference this was the occurrence, this was the practice in Clark County for a little over a year, ending at the end of 2024, and it was and still is for a couple years how the city of Las Vegas handles Fremont Street as well, is this type of system to focus on these areas where there is a heightened risk to the public safety because of the volume of people. Second, under subsection 3, in a county that establishes a corridor, so this, again, we're speaking like right now about Clark County, a person who is charged with, or convicted with a crime in the resort corridor or open out corridor, and I want to make this distinction, and I'm happy to answer any questions on it, but just so for a first offense, it is not a mandatory order out. We are seeking to get the repeat offenders. First offense, not mandatory, but if at the discretion of the justice of the peace, they can order that person to not enter the corridor for up to 1 year. Up to 1 year, and it's permissive. For any second and subsequent offense, it is that they must order them out of that corridor, and it has to be ordered out at a minimum of 1 year. So that's the difference between a first offense and a second and subsequent offense. We are obviously targeting those repeat offenders, which we have been dealing with on the strip for a while now, to make sure that we can keep that area safe. Now, importantly, and for constitutional reasons, of course, there are exceptions. If I am subject to an order out, there are exceptions, and I explained this to the judge at my sentencing. And I can go through all the details, but for purposes of brevity, there are things for like doctor's appointments. If I take public transportation and it's going to pass through there, I inform the judge at sentencing, Judge, I have these activities that, I have to visit my doctor in the corridor for these reasons. And there's an exception made for the time and the duration and all of that in which you can enter the corridor for those types of activities. It is not a one-time request. So at sentencing, if you have changed circumstances between the time you're sentenced and in the course of your sentence, then you do have to go see a doctor. You just inform the court again, and the court will consider whether or not the court wants to grant that exception for you to enter the corridor. That concludes section 49, because I wanted to kind of get to the heart of what we're proposing in this bill, but then I'll go back and start with section 9. And I want to pay a little bit of attention to section 9, because between last session, and even during last session and now, I think there's been some misunderstanding about what's being proposed. And I want to make very clear, we are not proposing a corridor court or an order out court. We are not. It is permissive. It is entirely up to the Justice Court whether they want to form a court or assign a couple judges to handle it, but we are not requesting the mandate of forming a court in this. We're making it permissive, and that is all. And I would note when there was a corridor court in Clark County, and that, like I said, there still is one in the city of Las Vegas, there were judges assigned specifically to the cases that would come out of the corridor court. And all those courts operated under the resources that they had already had allotted to them. And we were receiving a lot of information about the efficacy of those courts, and that's what we're seeking to get put back in today. But I say that to transition to section 10. And section 10 in a lot of ways is, you can consider it one of the most important sections of what we're proposing today, because we have an issue that we are trying to solve. And I want to make that 100% clear. We are trying to solve, and we are here today based upon advice of everybody who works in these areas about what we think the best way is to solve this issue. But if the data tells us that we are not attacking the problem the correct way, you can guess that we're going to be back here and say, would you please help us? We need to fix it. We got it wrong, whatever the case is. But without the data, we can't track really meaningfully how successful we are at this. So section 10 has a list of data requirements there's two types of reports that will be submitted. It'll be submitted annually to the Nevada Legislature and monthly to the Clark County Commission. And we want this data to be known. We specifically want it sent to the legislative branches so that you guys can perform your oversight and policymaking functions, so that you see the data that we see. So if we come back and we want to tweak the program, we want to find some other program that might help us address the problem more efficiently, that we're all looking at the same data. So Section 10 just prescribes that type of data. You can tell when you look at it, and I'm happy to walk through those if you'd like. Otherwise, you can tell looking at that data that we do have a focus on repeat offenders. We want to know the repeat offenders, whether this is working to minimize the number of times that they come back and commit crimes. If it is not, all of those issues. So that deals with Section 10, and then transitioning now into the remainder of the bill, and it's just Sections 1 and 2. Section 1 deals with assaults on employees, and Section 2 deals with batteries on employees. And we're appreciative that we've been in contact and working with, and we appreciate the help of the culinary union in addressing some of those issues that are occurring and what we're trying to prevent. This section, as an initial matter, it only applies to an employee of the bill defines hospitality employee who is either in uniform or wearing identifying badging. There's plenty of reasons why we think that's the best way to do it, but that is a requirement in order to receive these protections. If that employee is within the corridor wearing that information, we are asking that they be treated the same way of the kind of protected class that we have related to utility workers and school workers and things like that. So where if there is what would usually be a simple battery, no guns, no deadly weapon, no substantial bodily harm, that typically is a misdemeanor. If you are a member of the protected class, like the school workers, utility workers, hospital workers, it is not a misdemeanor, it becomes a gross misdemeanor. Similarly, and that applies to both assaults and batteries, and then also equally applicable to assaults and batteries. If you are the victim of a felony battery or a felony assault, that would be assault with a deadly weapon or a battery with a deadly weapon or a battery causing substantial bodily harm, typically punished. This group, we are asking to be in that group of protected people where it would be a Category B felony instead of a Category C felony. And those are the summation of the changes that we're requesting this body to consider today. I'm happy to answer any questions. I really appreciate having the opportunity to testify to this, and if there is any questions for me or Ms. Valentine, happy to answer them.
All right, thank you so much. It looks like we do have a couple of questions. I'm going to start with Senator Ellison.
Thank you, Madam Chair. I just wish this could have went farther than what it is. I know the population at 700,000 is what your cap is, and you got to have a city that big. But the problem is every county in this state, bad stores, title companies, banks. The problem has got so bad with these people going in and causing these problems. I don't know what to do at this point in time, but the problem is they'll go in and rob a store and walk out, and you can't do nothing to them. The police won't arrest them, even though there's theft. So the problem it's really got out of control. And even a little town like Oco, it's totally out of control. As a matter of fact, there's a group putting together right now to go in front of the city council because of this problem. They've done everything they could at this point in time to try to control it, but now they've got to do something. They're not taking reports. They're not arresting. Because they said they can't, and I don't believe that. So I was hoping you to, went a little farther with this, but I can understand with the population down there and what you're going through, mostly the transient population that are down there. So if you got any ideas what we could do, I really appreciate it. But it's got to the point where people are being beat up, they're being robbed. It's got out of hand, and it's everywhere in the state.
Madam Chair, briefly through you to Senator Ellison.
Oh, please go direct.
Okay, thank you. Matt Griffin for the record. Senator Ellison, I do know, with respect to the city of Las Vegas, they are operating under their city charter.
Yeah.
So obviously the city charter is governed by this body here as well. I'm happy to help you, and I'll take a look at the Elko City Charter. There might be authority existing in there, but your sentiments are certainly well received from our side.
I really appreciate any help we can get. We'd really like to have you to do that. Thank you.
All right, I think Senator Pizzina had a question. Please go ahead.
Thank you so much, Chair, and thank you both very much for the presentation. I was curious about enforcement. So if someone had committed one of these crimes twice within a 2-year period and were not allowed into the resort corridor, how do you enforce that? How do you know that particular individual has committed that crime just with how busy the resort corridor is and are able to enforce keeping them away? Thank you.
Thank you, Senator Pizzina, for the question. Virginia Valentine again for the record. Resort security has many ways to, frankly, some of the people that maybe are the worst offenders, they have been on this property. Some of them have been trespassed hundreds of times. So between either license plate recognition, facial recognition, their security people being on the field, when these individuals walk on the property, usually if they see someone from security, they will leave and there's no incident at all. But if they see them and they're trespassed and they've been trespassed and asked not to return, they may be trespassed again. If they are creating a second crime, then they'll be trespassed again. And when it gets to that level where it's just clearly a repeat offender, at that point, they may call Metro. So Metro has, I think, something like maybe 240 or so officers in the resort, at least in the Convention Center Area Command. We have thousands of resort security people on the ground. And the people who are there a lot and who are the people the resort court is really helping to reduce the recidivism with, they've been there so many times that they are recognizable. Thank you.
All right, any other questions from members of the committee? Not seeing any. Thank you so much for joining us this afternoon and providing all of those answers.
Thank you very much.
I will invite our next presenters down to the front. And please go ahead whenever you're ready.
Yeah, good evening, Chair Scheibel and members of the committee. My name is James Zarenda, D-Z-U-R-E-N-D-A, Director for the Nevada Department of Corrections. And pursuant to NRS 209.4888, I'm requesting for NDOC, Department of Corrections, to be able to review all nonviolent sentenced offenders before their release eligibility to transition supervision into our communities. According to the NRS, NDOC has the authority to release under community transitional placement offenders within 18 months or less remaining of their sentence or eligibility date. The communities of Nevada have more resources and services to assist these individuals in becoming successful in order to reduce victimization in our communities. The offenders can be supervised and monitored if placed into community programs and job placements. It is more dangerous and less successful if NDOC places them directly into the community at the end of their sentence without a step-down approach to re-entry and level of supervision while they are out there. Additionally, it is more fiscally prudent to allow those low-risk offenders to house in the communities as opposed to being housed in one of the NDOC facilities. If 500 offenders were able to participate in these programs, that could have a cost-saving result of over $2.5 million each year. Many of the eligible offenders who are, or those that are currently residing in the NDOC camps, transitional housing centers, and assignment to various programs that include education, reentry, substance use disorder, and other programming. It is most likely going to affect almost all those currently in our NDF, Nevada Department of Forestry conservation camps, prison industries ranch work programs, offenders classified as community trustee, and those in the programs that were funded for offenders within already 18 months of release, such as vocational programs such as cosmetology and vocational village. These offenders could be considered to remain in these outside funded programs if it is determined best for their individual's future success. This would also give the offender the opportunity after reclassification to replace all those other offenders that were released from these centers. Approximately 6.5% of the offenders currently assigned to the substance use disorder, reentry, and educational programs or prison industries are eligible for community transition as of 11/3 of 2025. 18.4% of those currently eligible are assigned to such programs as work detail. Of those currently eligible, 40.1% are from the camps or transitional housing, which equates to about 307 offenders. This is nearly a quarter of the 1,285 offenders that are currently housed in camps or transitional housing facilities, which may be immediately transferred to those programs taken in effect. Based on this week's population and criteria set forth, NDOC has a total of 770 offenders currently that could be eligible to the criteria under this supervision. Included in this data are set is anticipated releases of locations of 770 offenders, where 680 of those would be released to the Clark County, Washoe County, and Carson County currently. For eligibility criteria, it would be no sex offense convictions, no violent offenses on a current booking, must be within 18 months of any possible release, must have served over 50% of their maximum term, no felony or ICE holds, must be at least 6 months from any major infraction, must be at least 12 months from a violent disciplinary infraction, and no escape history from a medium or above facility.
Good afternoon. My name is Don Southworth, DONSOUTHWORTH. I'm the Chief of the Offender Management Division with the Department of Corrections. One of the things that we looked at when looking at standing up this program was how many offenders would actually qualify and be able to participate in the program. So as Director Zarenda said, we currently have 770 offenders eligible for the program, but of those offenders, how many of them will remain in Nevada post-release? How many of them will meet the other criteria that we would have for them? And based off of that, we looked at how many staff would be needed to stand up this program, what would be the duties of those staff. And so what we've identified is part of this bill includes appropriations to hire 12 staff members. This would be 7 Inspector General officers. These are Category 2 peace officers. 5 of them would be based in Clark County, 2 of them in the north. What many of their duties would be is doing the initial home inspection, working with compliance on these offenders, doing the urinalysis tests, those types of things. There's also 3 caseworkers that are primarily going to be working on risk assessments, case management, making sure that we're matching those offenders with whatever resources are available in the community, and then an administrative assistant to help assist the staff. And what we found is we're looking at potentially an initial influx of over 500 offenders that would be released from NDOC custody into the community. Many of these offenders are already in the community, as the director said, whether they're minimums or trustees out working in the community, but they would leave our custody, and the idea is that when these offenders leave our custody, we can then backfill those lower, more fiscally responsible beds with other offenders that become eligible, thereby creating additional cost savings going forward in the future.
All right. Thank you so much for your presentation. Do we have any questions from members of the committee? We'll start with Senator Orenshaw.
Thank you, Chair. Thank you, Director and Deputy Director, for the presentation. My question, that's 770 offenders. Is that the number of persons eligible for parole who don't have anywhere to go, or is that a different number? And if it is, could you give me that number too?
So James Render, for the record, these are offenders that are eligible based on the criteria that I just said. However, what will knock them out of eligibility is if they do not have a residence to go to. Those inspector generals will be inspecting their places of residence. If they they have no residence, if they're homeless, if they have no residency that they can actually reside in that has an owner or a renter that will make an agreement with us, they will be knocked out of that eligibility. So it would really just be those that met those criteria that I mentioned and have a place of residence that they're in agreement to sign off to say that they're okay with them being in their housing.
Thank you. And brief follow-up, Chair? So I'm sorry if I'm not getting it right off the bat. The 770 then are the eligible persons who do have a place that's suitable to go to?
So James Renner, for the record, suitable and non-suitable. So it's all of the above, have 770. And when we do go through the suitability of their housing, those numbers will come down. We did not put the 770 category with reducing them from housing because by the time the program comes up, they may have a residence that they can go to. They may have a sponsor that will sponsor them. So this is everybody, including those that are homeless or have nowhere to go.
Okay, thank you, Director. Thank you, Chair.
Other questions from members of the committee? I just have one. I was hoping you could explain why this would be housed in the Department of Corrections as opposed to being part of parole and probation.
So James Render, for the record, when we were coming up with this program, we would have it under Department of Corrections to keep the consistency of what we were currently doing, whether it's still working at our camp, still working in our prison industries, having the same program or job that they were currently in, so it didn't disrupt the reentry that we already were working on. When it goes under to parole, it could potentially change their whole program structure. We just wanted to have those low-level offenders consistent to what we already did, and also adding in the additional programming for them that we see that the community has that we don't offer, if that helps.
All right, thank you so much. I'm not seeing any further questions for you, so thank you for your presentation and your time. We will move on to the next presenters. And I believe this will, well, okay, perfect. Come on down, begin whenever you're ready.
Good afternoon, Chair Scheibel, members of the committee. Thank you so much. I'm here today, Teresa Benitez Thompson, for the record, Chief of Staff to Attorney General Ford, here today specifically regarding Section 58 of the second reprint of Assembly Bill 4 on the printed copy that's starting on the bottom page of 59. So the purpose of the amendment is to provide the Department of Corrections with more time to implement the new offender tracking management system to comply with the new time credit system approved by this body in Senate Bill 413 of the 2023 session. As a policy, the Attorney General's Office supported Senate Bill 413 in 2023, and we continue to support the policy to this day. But we are cognizant of the Department of Corrections' need for more time to implement the management system. Without the management system, the rate of habeas cases in the Attorney General's office will multiply without the new tracking system without it being properly implemented. Therefore, the language that you see before you in Section 58 extends the effective date for the new time calculation system from July 2026, that would be this upcoming July, to July 1, 2027, while also holding inmates harmless between the initial effective date of the Senate bill and the new proposed date of July 1, 2027, because ultimately that's the right course of action for the 10,951 inmates in NDOC's custody at this time. And I will stand open for any questions.
All right. Any questions from members of the committee? All right, I don't see any questions, so thank you so much for your time and your presentation. I think you are the last group of presenters. So first, let me just ask my committee, are there any presenters who you would like to call back down to the witness stand to ask additional questions, things that came up during this testimony? I'm not seeing anything, so I will invite our original presenters down if you'd like to make any pre-closing remarks. to the table now, or we can move into testimony. All right, we have concluded the presentation and the questions. Just so I can set some reasonable expectations on our timing here, I want to ask first for everybody here in person in Carson City, could you just raise your hand if you're here to testify in support? Okay, and if you're here to testify in opposition? Okay, and if you're here to testify in neutral? Okay, great. We love having participation. I think I am going to have to limit testimony to about 2 minutes per person if we want to get out of here before my baby is born. So I will limit testimony to 2 minutes per person, and we will start with and I see you guys in Vegas too. Don't worry. We'll do Vegas, and we'll also do phones. That was just to give me a sense of the volume of testimony. So we will start with in-person support testimony on AB4 here in Carson City. And please go ahead when you're ready.
Good evening, Madam Chair, members of the committee. For the record, I'm Paul Enos. I'm the CEO of the Nevada Trucking Association, here today to support Assembly Bill 4. We want to thank the governor for bringing this measure. We do believe that this is something that will help enhance the quality of life of all Nevadans. We also appreciate, specifically in sections 52 through 55, the enhanced penalties for DUIs. You know, our truck drivers share the road with these folks, so we want to see, you know, not just our truck drivers safe, but every Nevadan that's out there on our road. So we do appreciate this bill and are in full support.
Good evening. I am Adrian Hunt, representing the Las Vegas Metropolitan Police Department in support of AB4. Chair and members of the committee, AB4 strengthens our ability to protect the people who keep Nevada running. In short, this bill gives law enforcement the tools we need to keep our streets safe, the support of our workforce, protect victims, and ensure Nevada remains a secure destination for residents and visitors. For these reasons, LVMPD respectfully urges your support of AB4. We would also like to thank the Governor Lombardo for bringing this bill forward. Thank you.
Good evening, Madam Chair, members of the committee. Good to see you. For the record, Trey Abney, here today representing NFIB, National Federation of Independent Business, Nevada's small businesses. We are in strong support of this bill, specifically Section 7 when it comes to retail theft and smash and grabs. As you can imagine, large big box stores and others have teams of people in other locations they can send people to when they are a victim of a crime, but our very smallest businesses don't have that. Sometimes that is all that they have, the only store they have and the only inventory they have. So anything we can do to protect them, we support. Thank you, Madam Chair.
Thank you, Madam Chair, members of the committee. Russell Rowe here on behalf of Boyd Gaming Corporation. First, want to thank you for consideration of this bill. We do think it is a critical piece of legislation, and we strongly encourage your support. Thank you so much.
Good afternoon, Madam Chair. For the record, Jason Gray, G-R-A-Y, Vice President, Government Affairs for MGM Resorts, here to testify in support of Assembly Bill 4. We too would like to thank Governor Lombardo for adding this matter to the special session agenda, and to you and this committee for hearing the bill. The provisions in this bill will strengthen important deterrence and enforcement tools to improve public safety and combat repeat offenders in an order-out corridor to protect visitors, employees, and Nevadans. Language to strengthen penalties for offenses committed against hospitality workers will further affirm this body's long-standing recognition of the importance of the hospitality workforce to the proper functioning of the tourism industry and, by extension, our state's economy. And it demonstrates that crimes committed against hospitality workers will not be tolerated. The provisions also contain important new and needed requirements relative to reporting that are intended to inform evidence-based decision-making relative to order-out offenses, among other matters. Our state's travel and tourism industry employs 437,000 Nevadans, or 28% of total employment, contributes 24% of the state's general fund revenues, and comprises $98 billion in statewide economic impact. These provisions are intended to ensure that priority public safety issues counter to a thriving tourism industry and the safety of its workforce are properly addressed and mitigated. We thank you for your consideration and urge.
Good evening, Madam Chair, members of the committee. For the record, my name is Nick Schneider, Director of Government Affairs for the Vegas Chamber. For the sake of brevity, I will go ahead and echo the comments of my colleague, Mr. Gray here. We're here in strong support, particularly in regards to the provisions around the safety around the Strip corridor.
Thank you, Chair and members of the committee. Joe Hill with the Retail Association of Nevada. We support AB 4, specifically Section 7, as it would help keep our workers and customers safe and overall generate a safer community. We would like to thank the governor and legislature for working on this ongoing situation. Thank you.
I haven't testified in here before, so I wasn't quite sure how the buttons work. Good afternoon or good evening, Chair Scheibel, members of the committee. For the record, Leslie Pittman here today on behalf of Red Rock Resorts, and full support of AB 4, particularly sections 1, 2, and 46. I'm here to emphasize the importance to the entire Southern Nevada gaming community of keeping our resort corridor employees and visitors safe, as many of them are our customers as well. So would appreciate your support for this legislation. Thank you.
Thank you, Chair and members of the committee. Nicole Rourke, representing the City of Henderson. We're here in full support of AB 4 and really appreciate the victim-centered approach that this bill has taken to protect residents and to give additional tools to law enforcement. We're especially interested in Section 3 and the addition of social media to the stalking definition that we believe will help keep people safer than they are today. Thank you.
I'm not sure if your microphone is on. Is the red light illuminated?
Oh,
There we go.
you hear me now? I apologize. Good afternoon or good evening, Madam Chair, members of the committee. My name is Carlos Lasane. That's K-A-R-L-O-S, L-A, capital S-A-N-E. And I'm the Regional Vice President of Government Affairs and Community Affairs for Caesars Entertainment. On behalf of the thousands of hospitality workers and the millions of tourists who visit Las Vegas in the Strip corridor and beyond, I come before you today and humbly ask for your support of AB 4. The success and failure of a tourism destination is closely related to providing tourists and our employees with a safe and secure environment. Implementing laws that protects visitors and our hospitality employees is crucial to deterring crime. By establishing a safe and secure environment, it safeguards the local economy and protects Vegas's reputation, and we can ill afford to lose our guests, our employees' confidence as it relates to safety. I know that there's recent data that report crime is down. What's critically important to note is that so many crimes go unreported, and for a myriad of reasons such as the fear of legal entanglement, embarrassment, language barriers, and cultural obstacles, and a lack of time stops the victim from reporting. All crime isn't violent. Theft, fraud, property damage, disorderly conduct, and trespassing is a huge issue, particularly as it relates to the habitual offender. Without legal consequences, these crimes can escalate. We reviewed the crime bill and understand its importance, and on behalf of Caesars Entertainment, we are in full support of AB 4. Thank you so much for your time.
Harrison Bond, Harrison-Bohn, on behalf of the Latin Chamber of Commerce, here in strong support of AB 4. We want to thank the governor for placing AB 4 on the proclamation, which will provide our law enforcement and prosecutors the tools they need to keep Nevada communities safe. These added tools are vital for our small business community who rely on effective law enforcement so they can focus on conducting their business. Small business deserves to feel safe in our community, and we encourage you all to support AB 4. Thank you.
Good afternoon, Madam Chair and members of the committee. For the record, Miranda Hoover with 3C House, representing the Energy and Convenience Association of Nevada. The average national for state retail theft thresholds, including Washington, D.C., in comparison to the penalty outlined in Section 7, is $692.16. Bringing Nevada back to the $750 threshold will put us back in line with the national average. Our convenience stores are in strong support of Section 7, and across the country, our convenience stores are seeing an increase in smash and grab incidents. The National Retail Federation notes a 93% increase in shoplifting incidents since 2019. And according to the U.S. Chamber of Commerce, 8 in 10 retailers report increased aggression and violence during thefts. At our convenience stores, when a tobacco product is stolen, it is generally stolen through violent means and is stolen with the intent to resell. We believe the implementation of this bill will help to deter future theft incidents, which will help protect our convenience stores and staff. For these reasons, we urge your support. Thank you.
Good afternoon, Madam Chair and committee members. I'm Eric Hansen. I'm the Chief Sustainability and Government Affairs Officer for Wynn Resorts. We echo the comments by the Resort Association and also thank Governor Lombardo for bringing this critical legislation forward. The Wynn is home to 13,000 employees, and we see visitation of over 20,000 guests per day. We are here in support of AB4 because this bill will enhance the safety of those 13,000 Nevadans when they're at work, our housekeepers, our security personnel, all the people that make our resort what it is, as well as our guests that expect a safe visit to Las Vegas. Wynn Resorts is also supportive of the data component, allowing elected officials, resorts, and the public to understand what is needed to determine where resources are best allocated, and finally, to evaluate the effectiveness of any resort court and diversion programs. Thank you for being here, and we urge your support.
All right, thank you everybody who came down to testify in person in Las Vegas. We'll move now to Carson City. We will move now to in-person support testimony in Las Vegas. Please go ahead whenever you're ready.
Thank you, Chair Scheibel, members of the committee. My name is John Jones. I'm here on behalf of the Clark County District Attorney's Office in support of AB4. We want to thank Governor for bringing the bill, the committee for hearing it, and we urge your passage. Thank you, Chair.
Thank you. I don't see anybody else coming forward to give in-person testimony in support of AB4 either in Carson City or Las Vegas. So we will go to the phones, please, for support testimony on AB4.
If you'd like to testify in support on AB4, please press star 9 on your phone to take your place in the queue.
Good afternoon, Chair Scheibel and members of the Public Safety and Security Committee. This is Pam Del Porto, and I'm calling on behalf of Nevada Sheriffs and Chiefs Association, and we're calling in full support of Assembly Bill 4. We appreciate all the stakeholders working on this bill and the governor for submitting it under the proclamation for special session, and we also appreciate you as committee members hearing this bill both for you today. So thank you, and again, we urge your passage. Thank you.
If you have recently joined the call and would like to testify in support on AB4, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in support at this time.
All right, then we will move to testimony in opposition to AB4. We will start with in-person testimony here in Carson City. Please go ahead whenever you're ready.
Thank you, Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. I am the Nevada State Director of the Fines and Fees Justice Center. The word stakeholders was thrown around a lot in this hearing today, and I want to be abundantly clear. In the 223 days since the original version of this bill was dropped, there has been the least amount of meaningful stakeholder engagement that I have seen on any major piece of legislation. In fact, in my 8 years of doing this work, this is the least amount of meaningful stakeholder engagement I have seen at the state or local level. With that being said, I'm going to go through a few reasons that we oppose this bill. When we tried the Strip corridor and the court, it was a failed experiment. It was a revolving door of incarceration for our homeless population and a revolving door of fines and fees for those who were lucky enough to have the money to pay. We were told today to ignore the data that crime is down because it doesn't tell the whole picture. We were also told that when the corridor court was in existence, crime was down 10%. So I guess data only matters when it serves the position that we are pushing. This bill does nothing to address any of the root causes of crime. It simply is a net widening measure which has failed time and time again. That is why no data was provided to show why this bill would work. We are going to be sending people into NDOC when they are currently in a crisis. Despite the best efforts of the director, who I have deep faith in, we are seeing a large amount of overdoses, we are seeing a high rate of violence, and we are going to be taking low-level offenders and sending them into these prisons. For these reasons, we ask you to oppose.
Good afternoon, Chair Scheibel, Vice Chair Flores, and members of the Public Safety and Security Committee. My name is Paloma Guerrero, P-A-L-O-M-A-G-U-E-R-R-E-R-O, on behalf of the Clark County Public Defender's Office. Our office and the Washoe County Public Defender's Office has submitted Smart on Crime amendments that still address public safety but reduce some unnecessary harm to our communities. I'm going to talk about the smash and grab amendment that we proposed. This is going to be Section 7 of AB 4 and our proposed amendment number 1. I think the issue that we have here is that we think the language is too broad, and as we heard from the presenters, they think our language is too narrow. I think the answer here is somewhere in the middle, but that would actually require them to sit down with us and speak, which has yet to happen, and we're at day 4 of special session. So the issue is that the language does not require that the damage relate to the damage to security measures to gain access to the merchandise at all. So it could be any property damage done to anywhere in the store. This sweeps in conduct far beyond what smash and grab is, and the presenters were the ones using the term security measures, but that term is nowhere in the proposed statutory language. Our proposed language is more targeted, and we would be open to include the term of damage to security measures instead of barriers, which is the language that we use, which better aligns with what the presenters were using and are saying that the smash and grab crime is. And because we expect this to convert what would currently be misdemeanors and low-level felony offenses into more serious felony convictions, our amendment also proposes that instead of a Category C felony, it go down to a Category D felony. This is a small but important change that better conforms with other Nevada property crimes. Our goal here is to ensure that the punishment fits the crime and also maintain proportionality. And I'll hand it over to my colleague from Washoe.
Good evening, Chair Scheibel, Vice Chair Flores, and members of this committee. For the record, my name is Marcy Ryba, R-Y-B-A, and I'm appearing on behalf of the Washoe County Public Defender's Office, and I'm testifying in opposition to AB 4. I echo the comments that we've just heard today, and my remarks are going to focus specifically on sections 21 through section 24 of AB 4, and in reference to the SMART amendments that we've submitted. These sections of 21 through 24 address individuals who've entered a plea, but whose convictions have been deferred. So that means that contingent upon them completing certain court-ordered conditions, like a treatment program, these charges can be dismissed. In other words, at the end of it, this person is not convicted. And when we look at section 22, that's for someone that completed drug court. When we look at section 23, that's for someone that completed mental health court. And when we look at section 24, that's for one of our veterans that completed veterans court. Despite completing these courts, AB 4 would prohibit them from having their arrest sealed automatically, even after they've met every obligation and the case is dismissed. And this creates a significant and unnecessary barrier. Preventing the sealing of records for individuals who are never convicted imposes harsh obstacles to employment and housing, and these are some of the most important factors in preventing future justice involvement, supporting long-term stability, and allowing them to continue to have their children. These individuals have done exactly what the court required, demonstrated rehabilitation, and earned dismissal of charges. Yet under AB 4, they would still carry that permanent weight of an arrest record. Individuals charged with elder or child abuse could still seek sealing of their records under NRS 179. However, this is a complex process which generally takes over a year, even with the assistance of counsel. And Nevada's been described as a legal desert, especially for our civil cases, so this is going to hit some of our rural people the hardest. Adding this additional workload will take away from those civil attorneys' time on other important matters. Our proposed amendment for these sections is consistent with a conceptual amendment which was accepted by the Senate Judiciary for SB 457 in this last session, and that conceptual amendment was number 11 of that form and adopted on June 1st, 2025, and would allow the court to make the determination if the sealing was appropriate. For these reasons, we respectfully urge the committee to adopt the amendment proposed by the public defenders, which restores fairness and ensures that Nevadans who are never convicted are not permanently held back from rebuilding their lives. Thank you for your time and consideration.
Senators, my name is Mark Pritchard, M-A-R-K-P-R-I-T-C-H-A-R-D. I'm a resident of Reno and the 16th Senate District. I'm testifying today as a private citizen to oppose Assembly Bill 4. I'm not convinced that the bill does much to increase the safety of the public, of tourists, or of Las Vegas workers. What it does do is criminalize a portion of the poorest of Las Vegas residents, many of whom need treatment for chronic conditions, not imprisonment. But consider another population, the non-citizens who work as cooks, housekeepers, dishwashers, cleaners, and so on, without whom the industry could not succeed. The bill does nothing to protect these non-citizen workers from the crimes of which they are more likely to be victims. For example, the bill increases penalties for certain forms of kidnapping, but does nothing to protect Nevada's residents and workers from the kidnapping that masked agents of ICE and Border Patrol are carrying out on the streets, in retail establishments, and as we saw yesterday in the city of Charlotte, North Carolina, even in churches. Nor does this crime bill address the issue of masks being worn by law enforcement officers or other tactics, such as non-standard uniforms, lack of identification, unmarked cars, cars without license plates, that some federal law enforcement officers practice to commit crimes with impunity. If this special session is intended to respond to an emergency, these are the crimes. That's the emergency that needs addressing. I ask you to vote no on this legislation. Thank you.
Good evening. My name is Kayla Maese, Kaylahmaese. I'm testifying on behalf of ACLU People Power. While ACLU of Nevada is opposed to this bill, as Executive Director Tarhasi Bula will share in his opposition testimony, I wanted to share that AB 4 failed to receive substantive amendments on the Assembly side that protect our communities from ICE impersonators, including women and children who find themselves in the human trafficking pipeline. The time is now to act before we see more kidnappings. We are hopeful that the Senate will consider adding provisions that protect our vulnerable people. Thank you.
Good evening, Chair Scheibel and Vice Chair Flores. My name is Marissa Crook, Marissa Crook, with the Washoe County Public Defender's Office. I'm addressing the third component of the Public Defender Smart on Crime amendments, and that's the amendment that relates to Section 53 and 55 of this bill. The first amendment that the public defenders have asked to be added to the bill is a look-back period for when DUI causing death has an increased penalty of 5 to 25 years instead of 2 to 25 years. As currently written, that enhancement will apply to if a person has ever had a DUI, including a simple misdemeanor DUI 40 years ago. This look-back period is a look-back period of 7 years, saying that that increased enhancement, the 5 to 25 years, applies if you've had anything within the last 7 years. This is consistent with the rest of Nevada criminal law. Under Nevada criminal law, if a penalty can be enhanced based on a prior misdemeanor conviction, there's a look-back period of 7 years. If a
penalty can be enhanced based on felony convictions, then you will see cases where there isn't a look-back period of 7 years. For example, the once a felon, always a felon statutes, the DUI and DV ones, as well as the Nevada habitual enhancement. So adding the 7-year look-back period would bring this statute into compliance with the rest of Nevada criminal law. Second, the Public Defender's Amendment would split up the penalties for DUI causing substantially bodily harm and those from catastrophic injury. Under Nevada law, substantial bodily harm can include anything as simple as breaking a pinky finger, because all it has to do is fall under something that creates prolonged physical pain. Since something that minor can create the 2 to 20 years the way it's currently written, we are recommending that it be split up into 1 to 10 year penalty for substantial bodily harm, and then the 2 to 20 for catastrophic injury, such as paralysis, hearing of sight, or hearing of loss. These two amendments, the look-back period, as well as splitting up the substantial bodily harm and catastrophic injury, would make the bill, if amended, more in compliance and consistent with other Nevada statutes. Thank you.
Thank you, Chair, members of the committee. Harrison Epstein, representing the National Lawyers Guild of Nevada. In an effort to save time, we just want to echo the concerns of all the testimony in opposition today. Thank you.
Good afternoon, Chair Scheibel and members of the committee. My name is Elisa Caffaretta. I am the Executive Director of the Children's Advocacy Alliance. We opposed this bill during the regular session over concerns that young people would be swept into the juvenile justice system, and we would prefer to see the state investing in training and support for young people to divert them and put them on a positive path. Our concerns with this bill remain, and we urge you to consider opposing the bill. Thank you.
Madam Chair, members of the committee, I echo the words of the people that object before me, and I'd like to see this bill stopped. I believe that it would put an undue burden on our law enforcement and our judicial system. Thank you.
And can you please put your name on the record? Can please put your name on the record for our secretary.
Tanya Freeman, Tanya, last name Freeman.
Good evening, Chair and members of the committee. For the record, my name is Tara Webster, Tara-Webster. I'm here on behalf of the Progressive Leadership Alliance of Nevada in opposition to AB 4. There are real human costs to this bill. It'll give the green light to racial profiling and increase felony charges, leading to harsher sentences and higher incarceration rates. Plan believes that community safety depends on holistically addressing the root causes of crime, such as widespread poverty, funding shortfalls for education, and mental health support. This is simply cruel legislation, and we urge a no vote.
Thank you, Chair and members of the committee. My name is Olivia Tanager, for the record, and I'm just going to speak to you for a minute as Olivia Tanager. We are here in November of 2025. I have friends that are afraid to go out to restaurants because they're afraid of being kidnapped by ICE. We have people who cannot keep on their utility bills. We have people who cannot afford to get around because we are not investing in public transportation. People are dying by the hundreds because of extreme heat. And so here we are for an emergency session that was called to increase penalties on people and further criminalize our Black and Brown community members. So I hope some of you will join me in my anger and frustration that we are here. I am now going to put on my hat as Olivia Tanager, Executive Director of the Sierra Club Toyabe chapter. I'm speaking on behalf of an organization dedicated to environmental democracy and community voice. We oppose this bill as an organization because it undermines the very principles of fairness and public participation that healthy communities and a healthy environment depend on. The proponents of this bill are touting that crime is down since AB 236, and therefore they can't point to any actual data supporting the need for these changes. Rushing this bill through a special session silences the community and contradicts the inclusive, transparent process that true environmental democracy requires. At a moment when Nevada urgently needs investment in climate resilience, public lands, and community health, this bill would waste millions on policies that make our state less just and less sustainable. With that, I urge your no vote. Thank you.
I don't see anybody else coming forward to give in-person opposition testimony in Carson City. So we will go down to Las Vegas for in-person opposition testimony. If you'd like to testify in opposition, please come forward and occupy those 3 seats in the front, and go ahead whenever you're ready.
Good evening. My name is Brennan Bartley. That's Brennan Bartley. I'm a constituent of Senate District 3. I'm a public defender at the Clark County Public Defender's Office, and I represented people in the corridor court for the last year of its operation. I'm here today in my personal capacity to explain to you what the corridor court and order out are actually like on the ground. The cases that were in the corridor court were overwhelmingly misdemeanors, nonviolent, or nonviolent misdemeanors. The reasons we were given for why we needed a corridor court were either not borne out by the facts or are already served by the rules of the Justice Court. The evidence, the verifiable evidence, is in showing that crime is down since the end of the corridor court program. My clients were promised that that program would be better for connecting them to resources that never materialized. And when we look at the people who were most severely impacted by these programs, it was overwhelmingly people who were homeless. I watched officers walk up to people who were doing nothing more disruptive than sitting on a planter box or stacking rocks and ask them their name so that they could arrest them for violating an order out. The people who I represented on charges of violating an order out, in my experience, 85% or more of them were homeless. And you would see these vicious cycles where a person would be in jail for months and you go back and look through their cases and you have to look back 3, 4, 5 cases to see anything other than violating an order out. These policies are failed experiments. They hurt some of the most vulnerable people among us. They turn our jails into more expensive homeless shelters, and they do nothing to advance the goals of criminal justice. What they do is make it easier for the 1 or 2 judges that would hear these cases to be chosen, to be bought by the powerful to rule against the powerless. Justice must never be bought. I respectfully urge you to vote no on AB 4. Thank you.
Good evening, Chair. John Piro, representing Nevada Attorneys for Criminal Justice, which represents hundreds of attorneys throughout the state of Nevada. This bill is not evidence-based. It's not research-backed. It's not transparent yet again. And most importantly, it's not an emergency measure. In fact, this bill runs contrary to the data, and I have the receipts. This past November 13th, the Nevada Independent, using stats and data, showed that crime is down on the Strip, without the Strip corridor court. On October 28th, the Review Journal published Sheriff McMahill, the sheriff of Clark County, saying that double-digit crime reduction has happened. On June 9th, Channel 8 Reno, DA Chris Hicks in Washoe said crime is down after coming to the legislature before and saying it was up. And then on November 9th, Lyon County Sheriff Pope said that crime is spiraling downwards. And just today, this evening, before I came and testified, I checked JoeLombardoNevada.com, his results webpage, and he says crime is down. I was here in 2019 with most of you that were here on this committee when we passed AB 236 and committed to evidence-backed reforms. Contrary to DA Hicks' statement this evening, crime is down. Nevadans are safer. And I was just in a sentencing commission meeting, and the results of that are that this biennium, Nevada is going to save $19,604,410 based on the AB 236 reforms. And at the next biennium, with the Smart on Crime reforms that we passed through AB 236, Nevada is poised to save $36,775,055. This bill seeks to bring us backwards, and we have tried to make Smart on Crime amendments that have been rebuffed at every turn. Specifically, that social media piece is dangerous. Criminalizing speech, we have laws already on the books that protect dangerous speech, but this proposal seeks to criminalize text messages between people who are insulting others. It removes the course of conduct language, so you could think of somebody who sends 2 bad texts after a bad breakup now being accused of stalking. And you could criminalize somebody who speaks on their own page, their own social media page. It's dangerous, and we have to stop this. This is not a process we should be rushing through. We ask that you do not pass this bill without our Smart on Crime amendments, and we ask that if they are not adopted, that you don't pass the bill at all. Thank you.
Dr. Elizabeth Glover, for the record, traditional spelling, last name Glover, sociologist and chairwoman for the NAACP Criminal Justice Committee, and we are in opposition of this bill. We believe in safe communities and accountable systems. So we believe in targeting the system and looking at underlying causes. We must dive deep and be interested in antecedent work. This bill doesn't address the root causes like housing, job, or education. Instead, it does just expand upon criminalization and increase policing, which we know will disproportionately affect low-income and marginalized communities, including our youth. This is a concern because when I compare our census data to the data put out by Nevada Department of Corrections, I'm seeing that Native Americans and Black Nevadans are incarcerated over 3 times of their presence in the general population. This proves that there is data, or receipts, as my friend said, of the disproportionate racism that our system embeds. And so I want to urge you and ask you all to instead get interested in policing patterns, arrest rates, prosecutor charging decisions, sentencing disparities, and fewer diversion opportunities. Let's target the why, and we will fix the problem. Thank you.
Good evening, Chair Trifle and committee members. For the record, my name is Matilda Miller. That's Mathilda Public Affairs Director for Native Voters Alliance Nevada, and we're in unwavering opposition to this bill. As my colleagues have stated, they all have the receipts, and the receipts showed us that this bill does not make Nevada safer. It expands punishment instead of reducing harm. It puts more people into a system that has already failed to deliver safety, stability, and true justice for the communities most impacted. We know what actually prevents crime. It's housing, it's treatment, it's mental health care, it's strong schools, stable jobs, culturally grounded services. Nevada does not have a shortage of punishment. Nevada has a shortage of the investments in the things that keep families whole. This bill sends more kids and adults into cycles that are almost impossible to escape. Indigenous families, Black families, and Latino families and underserved communities will feel the brunt of this bill. And when we talk about public safety, we have to talk about the safety of the people who are actually living through the consequences of this policy, not the convenience of a system that refuses to reform itself. Thank you.
Thank you, Chair and members of the committee. My name is Shelby Swartz, SHELBIE SWARTZ, and I'm the Executive Director of Battleborn Progress. Assembly Bill 4 is the same bad crime policy that we saw during the regular session. The main difference is that this measure has been rushed through during a special session in which public participation was limited. At a time when crime is down, this policy serves resorts and gaming rather than investing in solutions that address the root causes of crime in the first place. If passed, this bill will result in more fines and fees rather than solutions to support our communities. We've spent years building smarter, more compassionate, and evidence-based alternatives to incarceration. Throwing that progress away now is not only reckless, it is inhumane. Thank you.
Good evening, members of the committee. For the record, my name is Sean Navarro, Navarro, constituent of SD6, a proud rank and file member of Las Vegas Democratic Socialists of America, now 500 members strong. In Nevada exists 2 justice systems, one for the rich and the powerful and one for the rest of us. I find it highly ironic that Joe Lombardo is trying to jail more poor Nevadans, while his office just pardoned Elon Musk, the richest man in the history of the planet, of $400,000 of fine, couch change for Musk and his Boring Company. His company had over 800 environmental violations, including chemical burns for 2 brave Las Vegas firefighters. Also, NV Energy was just caught overcharging, or let's be honest, stealing $65 million from 80,000 customers, and yet they have received a slap on the wrist. For 2 sessions, Governor Lombardo has tried to lower the felony threshold from $1,200 to $650, yet when NV Energy steals $65 million, silence. For over 57 months, Las Vegas DSA has been the historic West Side distributing mutual aid to the unhoused community. These people huddle under bridges for a little bit of warmth and shelter, less than a mile away from billion-dollar casino properties. And now those same casino properties, instead of taking their billions of dollars and addressing this issue, are using the state and the police force to criminalize the unhoused. This bill will do nothing to keep people safe. It'll just simply put more unhoused people in jail. I think this is ridiculous. I think the whole special session has been an example of how Our legislator puts forth corporate interest in front of the interests of normal working Nevadans. We're not talking about housing. We're not talking about education. We're not talking about affordable childcare. We're talking about putting more Nevadans, disproportionately poor Nevadans and Nevadans, people of color and immigrants behind bars when there's so many issues to address. I guarantee you stop someone on the street, you ask them their top 3 biggest issues. It's not going to be crime on the strip. It's going to be housing, childcare, or putting food on the table. And I think the legislators should represent those concerns. Thank you so much for your time. And I strongly oppose this bill, and I hope you do as well. Thank you.
Hello, my name is Noah Cicero, Noah-Cicero. I am a normal Las Vegan, DSA member, Catholic. I work with the unhoused every month. I've worked with the unhoused, with the DSA, with the Catholics, with different organizations. I've stared into their eyes. I've held their hands. I've seen them beg for tents. I've seen them beg for food. I went to the St. Elizabeth Ann Seton outreach thing yesterday, and the room was filled full of people. And I want to say, I'm also a writer and a novelist, a poet. And to do a literary analysis, you've all seen Les Miserables. And so you really need to ask yourself, are you Inspector Javert or are you Jean Valjean? Like, who are you for with this? Are you with normal people, with the unhoused, with the struggling? Have you ever spent a day in prison? Have you ever spent a day in jail? Do you think seriously? And I respect you and I love you and I'm glad you guys are doing this and I'm glad you guys came here, even though Lombardo's thing is totally weird that he made you do this. But you're good people, I think. I think inside you know that you don't want other people to suffer. You don't want unhoused people arrested for very little reasons. You want the people of Las Vegas to be happy, to be gentle, to be meek, to be soft. And I hope that in your heart you are also soft and gentle and meek yourself. Thank you.
Good afternoon. For the record, Attar Hasibullah, first name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I serve as the Executive Director for the American Civil Liberties Union of Nevada. By background, I'm a civil rights attorney. We are here in strong opposition to this bill. And with respect to the points that were made about the resort corridor court and the order out provisions, I wanted to clarify a few points. I believe Mr. Griffin said a little bit earlier that Judge Levitt in Clark County had found the corridor court and associate order out provisions to be constitutional. That is not a court that oversees and creates binding precedent for the rest of the state and Nevada state law. By allowing for a resort corridor court to exist and order out provisions that would allow for banishment for people who are convicted or adjudicated to have committed the lowest level of offenses, because again, we're talking about a court that's tied to a justice court, not a district court. What you'd effectively be voting for is further privatization of our judicial system, just as the rest of our community has largely been privatized. There is no need for this type of court, and there's a reason why it's defunct. But this concept of privatization keeps rearing its head during this special session, throughout regular sessions. We all end up in these chambers to hear these hearings, and ordinary Nevadans want to know, are these hearings legitimate? Is there legitimate public participation, or are these scenarios where these vote totals are decided already because there's already been deals secured by major corporations to ensure that votes end up a specific way? We urge you to vote no on this, to protect the rights of all Nevadans and to protect against the continued creep of privatization of all of our systems of government. It's not sufficient that we end up here for a special session that's costing this much money to effectively do yet another giveaway for billion-dollar corporations while our ordinary community members are struggling. I also echo with respect to the provisions that Mr. Pirro mentioned. There remain constitutional issues and First Amendment issues. We don't encourage you to advance this. We encourage you to have courage. But I would say that the majority of people that we've spoken to and that continue to see these types of hearings continue to operate in dismay because they know that the vote totals here may end up leading to an outcome that was already predetermined. Thank you.
Hello, my name is Elijah Glover. I am against this. I want you to think about boys like me when you vote.
Kids make mistakes. I'm a kid who loves football, jokes with my friends, and wants to have a future. But I make mistakes. And laws like this make boys like me feel watched instead of protected. From the moment I'm born, they have a prison cell laid out for me, and laws like this get a pillow ready for me in those cells. Please vote no on AB4 because we deserve to grow up with opportunity, no fear.
Hello, my name's Leslie Turner. I'm here as a constituent today. I live in District 2 on the east side. And I guess the first, I'll keep it brief because most of the points were already made. But I think the question that I have is what emergency is being addressed in this entire special session? And that I think is something that the public really needs to know and understand. Crime is down. That's already been established. I get it. You know, the data is gonna be used accordingly by whoever wants to make whatever point. But ultimately, the data shows that crime is down, and it's actually been down for the past 50 years. And so, why are we rushing to pass a bill to address crime when that's actually not an emergency? So, I think that this bill has been argued. The public has spoken. Even now, we're still showing up in opposition. You know, I was actually cleaning my son's bedroom today. I had to leave, rush over here, stop and get gas just to come and give public comment because I wanted to be in person. But again, we already spoke on this during the actual session. We already had this dialogue. We already went back and forth. We already held the lines for over an hour. The public already spoke. So why are we here again when no emergency is being had? So I think that this whole process is super disingenuous. I think if you want to address an actual emergency, you can look at what's going on in NDOC as you're actively trying to put more people in there. There's people dying. There's been people who have been on the phones while rats have been running out of the actual trays of food being handed out to incarcerated people. And I know that it's possibly a struggle for some of you to see incarcerated people as human beings. However, these are people's lives, and ultimately it costs the state. The state just paid out $4.8 million, and there's more lawsuits that have been filed. So again, that should be an emergency. You should be looking at that and how to address that situation instead of actually trying to put more people inside. Again, this whole process is completely disingenuous. We didn't need a special session to address crime, amongst other things that were on the agenda, and I'll leave it at that. Thank you.
Hello, Madam Chair and Council. I'm here to testify in support of the bill. I got here late. You know that there hasn't been much organization online. I drove all the way down from my home.
We'll come back to support testimony. I want to get through all of the opposition testimony first, please. If you could take a seat,
Okay.
I will come back around.
Thank you. Thank you very much.
Sure. Is there anybody else in Las Vegas wishing to give opposition testimony in person? Okay, I'm going to go to the phones and finish opposition testimony first, and then I will allow some people to catch up who missed testimony in the position they want to testify in. So at this time, we will go to the phones for opposition testimony.
If you would like to testify in opposition on AB4, please press star 9 on your phone to take your place in the queue. Caller with the last 3 digits, 184, please press star 6 to unmute yourself. Once again, caller with the last three digits, 184. Please press star 6 to unmute yourself. Caller, you are unmuted and you may begin.
Hello there. My name is Amanda Strano, AMANDA-STRIANO. I am a resident here in the Senate District of 7. I urge you to vote no on AB 4. This bill is regressive and will allow for the establishment of a court for casino corporations and funnel people experiencing homelessness into the criminal system. This bill does nothing to protect those who are subject to kidnapping by ICE impersonators. Please vote no.
Caller with the last three digits, 364. Please press star 6 to unmute yourself.
Chair Scheib. Good evening, Chair Scheibel and committee members. For the record, my name is Noel Orozco. That's A-N-O-E, accent over the E, O-R-O-S-C-O. I'm the coalition coordinator for the Nevada Immigrant Coalition. We are here in opposition for AB 4 as it stands. The immigrant community is under attack and due process is being eroded by the current overreach of the federal government. Just yesterday in North Carolina, masked immigration officers targeted a church. And here in Nevada, we have experienced 2 anti-immigrant surges this year where our families were terrified to go outside, much like the families and communities in North Carolina right now. They're afraid to drive their kids to school, to go grocery shopping, and just as I mentioned, even to going to church now. These attacks push our communities further into the shadows, and they cause impacts for all Nevadans. Perfect example of the economic impact of the threat of ICE is Broadacre's swap meet being closed in late June. It's one of the largest employers in North Las Vegas, and the closure caused significant economic disruptions for vendors, and we've seen persistent fear even after the reopening. Anything less than substantive policies and meaningful protections is not just performative, it's a deflection from moral responsibility. The Nevada Immigrant Coalition urges our elected officials to take real action for our friends, our families, and our neighbors. We need meaningful protections for all Nevadans, regardless of their immigration status. And that means protecting sensitive locations, restricting any face coverings and or maskings of local law enforcement and the Nevada National Guard, and ensuring that Nevadans' data is not shared for immigration purposes unless there is a judicial warrant. And for that, we urge you to oppose this bill as it stands. Thank you.
Good evening, Chair Scheibel and committee members. For the record, my name is Denise Heredia, H-E-R-E-D-I-A, testifying in firm opposition to AB 4 on behalf of Return Strong. Thank you for allowing phone testimony and for choosing to support equal access to our democratic process today. When we opposed this bill during the legislative session, we submitted firsthand accounts from people inside NDOC describing medical neglect, excessive force, isolation, food insufficiency, and other human rights violations. That has not changed. If anything, conditions have worsened. More deaths, continued delayed medical care, understaffing, and failing communication systems. Even with a growing budget, NDOC still can't meet its basic obligations. We know NDOC is looking to release certain eligible people, and while that is a positive step towards decarceration, this bill simultaneously creates new pathways to incarcerate more Nevadans. That is not progress. You cannot reduce the population with one hand and expand it with the other. We cannot keep adding people to a system that cannot keep those inside safe. AB 4 ignores the root causes of incarceration. We cannot jail our way out of homelessness, poverty, or untreated mental health needs. If this is truly a safe streets and neighborhood bill, it should start by protecting Nevada's immigrant families, our neighbors, from the violent kidnappings happening all over the streets of our country. Nevadans deserve policies that strengthen our communities, not expand its collapsing prison system. We urge you to vote no on AB 4. Thank you.
Good evening, Chair Scheibel and members of the committee. Thank you for allowing the opportunity to testify telephonically. For the record, my name is Brandon Summers. I grew up and reside in Las Vegas, and I am in opposition to Assembly Bill 4. The original resort corridor court failed to live up to its promise. It failed to be a beacon of justice, and worst of all, undermines due process. I do not see why a failed court should get a second chance. Personally, I found myself in the Community Impact Court in 2018. And why, you might ask? It was for the act of playing the violin on a pedestrian walkway. While in court, I quickly learned that I would not get my day in court. Regardless of the intent of the court, the outcome was chronic inconvenience, and it was clear that this court would negatively impact the lives of many, namely street performers and unhoused homeless individuals. Despite never having a trial or a criminal conviction, in the face of numerous misdemeanor citations I received over the years, I am still left with an arrest record and a criminal record. A community court such as this will continue to have this effect on others, and many will plead guilty to low-level offenses in order to get on with their lives, and often as a means to get their personal property out of police custody. Senators, reinstating the resort corridor court via this bill poisons the larger intent of legislation. This bill is not ready as is. I urge you to vote no in the interest of the constituents and not to vote for the appeasement of the gaming and tourism industry. They care very little about the violation of civil and human rights. Thank you.
Good afternoon, committee. My name is Crystal Cooper. That is spelled CRYSTALCOOPER, and I live in District 18. AB4 does not protect immigrants who are at risk of kidnapping. We know this state has a human trafficking issue. And as someone who survives human trafficking in this state, I will say that the current version does not protect women and children at risk. And I apologize for my shakiness. I'm very upset. Anyone can dress up as an ICE agent and kidnap someone with the current version that they have presented. And instead of trying to speak for survivors, have us in the room so we can help you craft these policies instead of crafting policies that are going to hurt us. Not to mention, this bill is going to criminalize our poorest residents, and it's going to create a pipeline that is going to put people experiencing homelessness in the criminal system. This is not what we want, okay? You guys, please vote no. Vote no. I urge you as a survivor, as a constituent, and just as a human being. Thank you.
I believe that means I'm up. I was unmuted. This is Steve Evenson. I have the honor and privilege of representing people criminally accused of crimes throughout all Nevada courts. I just wanted to speak in opposition to this motion as it is rushed and half-baked. And like anything, if you put in something with bad input, you're going to get something with bad output. I'd like to note that specialty courts are not easy, that a lot of times criminal defendants on child abuse cases, and by the way, I'd like the committee or Legislative Counsel Bureau or somebody to tell me the difference between a misdemeanor child abuse case and a misdemeanor domestic violence case under the way our statutes are currently written, because I can assure you the district attorney's offices do not know the difference because everything's getting charged to the higher offenses. And so a lot of times people are charged with the higher offenses and they take a specialty court option to heal their family, to get back into a household, and to do that. Specialty courts are not easy. They are 18-month programs. They are intensive. They are supervision. And the carrot at the end of that stick is a dismissal for them so that they can get on with their lives. And to go through that process now and to have this legislative session in a hurry do what they're doing here is not appropriate. And I speak in opposition bill for that reason. In looking at the DUI provisions of the bill, and as I always tell my DUI clients, whenever they plead to anything, they are always at every legislature increasing the penalties and doing everything because people don't like DUI offenders. Well, let me just ask this simple question. two questions. Is there anything in this bill that modifies NRS 179 as it relates to the sealing of criminal records? Because the way I look at it, you're saying if anybody was ever convicted previously, they're now subject to these increased penalties. Under the NRS, it says specifically that if they're outside the NRS 179, if they're outside the 7 years, they get to have it sealed. I don't see anything reconciling that. And it's an odd thing to me that a 21-year-old can have a DUI offense, seriously hurt or kill somebody, and receive a 2-year sentence. Somebody who's 42 years old and had a DUI 21 years ago, but has lived an exemplary life since, as far as the record says, is punished more harshly. If these enhancements are going to be done, they need to be done better and in a better way. This is rushed and should not pass. Thank you for hearing me today.
Good evening. My name is Simar Jolly, SIMAR and JOLLY. I'm a part of Next Gen Politics Nevada. We oppose AB 4 as it stands. We want to keep it brief and echo what everyone else has said. This bill, it's progressive. It criminalizes the poorest people in our state. The juvenile justice changes push kids deeper into the system instead of towards rehabilitation. And I hope that after hearing all of the convincing and persuasive testimonies today, you will oppose this bill. Thank you very much.
Good evening, everyone. Thank you for your time and your beautiful energy. My name is Bridginix. That's spelled BRIDGIENIX. That is one word. I am a performing artist. I'm a circus artist. I'm a fire eater, dancer. I am also running for lieutenant governor for the state of Nevada. And I wanted to come to you guys as someone who has actually worked in the casinos, both as a direct employee, but also as a freelance artist who gets hired by third-party companies. I am constantly followed after my shifts. I am constantly harassed within the casinos, both by casino employees, but also by tourists and people who come to watch my sets. I strongly oppose AB 4 for the same reason many of you support AB 4. And I think the one thing that we all have in common today is that we want to see the end to harassment, right? We want to see the end to crime. But we all have different opinions on what is actually going to solve that. Enforcing a law that already exists does nothing to actually target the root cause of crime. The root cause of crime, as we all know, is going to be poverty, inequity, mental health, and addiction. I want to talk about addiction. A lot of the addiction that we see on the strip profits a lot of the people that are currently supporting this bill. So if you really, truly want to see those people stop harassing your employees, then implement something that will prevent it. Don't profit off of it and then still at the same time discredit it and put them into incarceration. The reality is that the AB 4 bill increases punitive penalties and mandatory sentencing that risks mass incarceration and racial disparities. The majority of the people in this room right now are white, and they are never going to experience the inequity as a result of this bill. Nevada needs an alternative that reduces crime, protects public safety, and uplifts all residents without deepening systemic racism. Why are we not talking about investing in prevention and opportunity? I think maybe it's because that takes a lot more money, that takes a lot more effort. But again, we need to target the cause, and that is what actually makes performers, artists, casino laborers feel safer. That is actually what prevents it. The other thing we need to talk about is scaling community-based public safety and crisis response.
And you have reached 2 minutes. I'm going to have to ask you to wrap up.
Okay. Of course, I would like more time, but we don't have that today. So in conclusion, I am asking everyone to strongly oppose this bill for the protection and safety of its residents. Thank you all.
Good evening, Chair and members of the committee. For the record, my name is Melody Hudilia, first name spelled Melody, last name spelled Judilla, and I'm the Deputy Director of Silver State Voices. I'm here to testify in opposition on behalf of Silver State Voices. I echo my colleagues' comments in opposition in solidarity with our partner organizations. Our vision for a healthy democracy includes healthy communities, and we do not believe this bill gets us there. We urge you to vote no. Thank you.
Caller with the last three digits, 000, please press star 6 to unmute yourself.
Hi, good evening. Doug Roberts here in Las Vegas, and I'm calling in opposition to this bill. I'm a proud ACLU member, and I want to echo everything that our director, Attar, has said. I testified in opposition to this bill back in the regular session, and not much has changed since then. This bill was obviously submitted by the governor. I don't even know why we are wasting time on this on a Sunday. Governor Lombardo vetoed a record number of bills this year, 87 in total. There's just no reason we should even give this bill a hearing. Just do what he does, just veto it and vote no. Thanks.
Yeah, hi. My name is Craig Hoffman, CraigHoffman. I'm a 46-year-old college student at University of Nevada, Reno. I learned 5 years ago that I've been autistic for my entire life. This is a problem because I have a criminal record from 2007. I did everything I was supposed to do, including getting a psychological evaluation. The psychological evaluation somehow failed to recognize an autistic person right in front of them. This is still happening to people. We need to be investing in mental health care and ensuring that people who end up in the criminal justice system are prepared to be returned to society. This bill needs to be opposed and thrown in the garbage. Thank you very much. Have a great day.
Hello, this is Kathy Fulkerson, CathyFulkerson, and I'm here in opposition to AB 4. I'm a resident of Reno in Senate District 15. This is a bill, this bill is an expensive solution in search of a problem. It's already been established that Nevada crime is down. The Washoe County prosecutor who began this hearing started by saying Nevada is safe, Nevadans are safe. We do not need tougher penalties. We do not need to broaden the scope of crime infractions. We do not need anything special for the Las Vegas Strip. This bill is costly and therefore a waste of money. How many bills died during the 2025 session because of a fiscal note? This bill is obviously not about public safety, nor does it improve the quality of life for all Nevadans, nor is it an emergency. We do not need to rush this bill. I believe this bill will actually increase robberies because it will rob Nevadans of our hard-earned money that could be put to better use elsewhere. This bill actually does nothing to address the current state of fear our immigrant communities and those who look like immigrants are now living with. The legislative body unanimously passed AJR 9, a resolution urging Congress to establish churches and schools as sanctuary areas. The Nevada State Legislature also passed legislation preventing ICE from entering schools without a warrant, but that bill was vetoed. These are the concerns that are emergencies. Why aren't those concerns being addressed by this bill? I urge you to vote no on this bill. As others have said, it's a waste of money and a waste of time. Thank you.
Hello. My name is Yesenia Moya, Yesenia I am a resident of District 2, and I'm strongly in opposition of AB 4. Back in June, at the end of the regular session, this bill was rushed through, and we still showed up. We had 5 hours of opposition testimony from the most important stakeholders that were kept out, directly impacted people, public defenders, advocates, families, and community members. So I ask you, what are you afraid of? What did Lombardo promise you or threaten you with? Why did the Assembly cut the phone lines? How does throwing more people into cages make Nevada safer? I live on the east side. I work within Nevada politics. My neighbors, my family, my loved ones, myself, we're getting kidnapped off the street, fighting to stay housed, struggling to feed ourselves and our kids, fleeing surveillance and racial profiling daily, while you complain about missing Starbucks or your planes. AB 4 creates new crimes, adds felonies, and mandates longer prison sentences, all while removing judicial discretion. This is a mass incarceration scheme and a fast-track deportation pipeline. Public safety cannot and should not be privatized. Corporate comfort cannot take priority over community well-being and the very workers who keep the strip running. If crime is down, and you know crime is down, why are you pushing mass incarceration? Why are you listening to people with no data and no expertise? Why let corporations shape enforcement policies while community members are silent? Public safety is housing and feeding our kids. This is vicious regression. This is the criminalization of poverty and the silencing of people who are most impacted. AB 4 and the special session are a cruel joke at the expense of our community. A disgusting perversion of what a real emergency session is meant for, like when our governor chose to starve our kids. So vote no on AB 4. You may ignore our voices today, but you will feel our power tomorrow because we protect ourselves. Pass this or don't, our people are organizing, and the power that you cling to is nothing but a silk screen, thin and fragile.
Chair Scheibel, members of the committee, thank you for the opportunity to speak. My name is Gerald Mays. That's GeraldMayes, and I'm the Executive Director of the NAACP Las Vegas Branch 1111. And I'm here today on behalf of our members. The NAACP wants safe communities. We want safe neighborhoods, safe workplaces, and a justice system that protects every Nevadan. Our concern is not whether we respond to crime, but how we respond. And on that point, I want to be absolutely clear. Our branch is vehemently opposed to AB 4. Our members just lived through a 40-day government shutdown where families were pushed into crisis. Many received just a humiliating $12 in emergency SNAP benefits, $12 to support an entire household. People were choosing between rent, food, and medication. We saw firsthand how instability creates desperation and how thin the margins are for working Nevadas. Against that backdrop, AB 4 is not only overly broad, it is tremendously expensive. It will significantly increase the costs of enforcement, incarceration, court operations, and long-term supervision. Yet none of that investment goes towards the things our members are begging for: mental health services, treatment, housing stability, youth programs, job pathways, and real community supports. Instead, this bill creates what feels like the only thing our government is making easier to access, and that's a pathway to become a felon, while leaving the rest of us to live in communities made more unstable, more desperate, and less safe. Nevada has worked hard for years to move toward balanced, data-driven approaches to public safety. That work didn't come overnight. It came from collaboration between lawmakers, community groups, law enforcement, and researchers who understood that long-term safety means investing in people, not just penalties. We built specialty courts, diversion programs, restorative approaches, treatment pathways, and improved re-entry systems because the data showed they reduce harm, reduce costs, and reduced offenses. We learned what works, and we have been moving in that direction deliberately and responsibly. AB 4 disregards all that progress. Instead of using data to guide policy, it widens criminalization, increases instability, and directs massive resources into the least effective, most expensive part of the system. It pushes us back toward approaches
And you have reached 2 minutes, so I need you to wrap
been
up.
proven not to work. For these reasons, on behalf of the members of the NAACP Las Vegas branch, I strongly urge this committee to reject AB 4. Thank you.
Good evening, Chair and members of the committee. My name is Hector Fong, Hectorfong. I'm testifying as a constituent of Senate District 6 in opposition of AB 4. I want to start off by saying I really, really appreciate the opportunity to give phone testimony on this beautiful, cool Sunday evening. I'm in opposition to AB 4 because as so many people have said, it offers no solutions to a non-problem. It only offers incarceration. It doesn't address any of the root causes of crime, like housing, jobs, and whatnot. It's actually making it worse because once you have a record, everything becomes so much harder and you're just stuck in a cycle of poverty. So if you guys are looking for a real crisis to address, our communities, our friends, our families, our neighbors, our students are living in terror. They're being kidnapped, and we need meaningful protections. We have to protect the immigrants who help run this state, who are a part of our communities. But I just want to ditto what all of my fellow Nevadans have said, especially the attorneys and the recommendations, and especially what was said about NDOC. Nevadans deserve better than mass incarceration. We're basically turning Metro into the Las Vegas Merchandise Protection Department. So I urge you today to please vote no on AB 4. Thank you.
Hello, my name is Shaylin Pilling, SHALYN I am a Nevada resident here in Senate District 18. I am in strong opposition to AB 4. As has been previously mentioned by many of my fellow Nevadans, this bill does nothing to help the community. It only is going to inflict more harm and cause many, many Nevadans to get into a system that is incredibly hard to escape from. Instead of going with the data-informed approaches of restorative justice and diversion programs, we know through many, many, many studies that helping people, giving them opportunities, giving them a leg up, and providing resources so that they can lead different lives and build their life up works so much better to create a safe community where all members can be involved and all members can be heard. This bill really just focuses on increasing the pipeline and increasing recidivism rate. We are targeting young folks in our community who do not need to be targeted. They need to be assisted so that they can lead fulfilling lives going forward and not harmed because of the incredible increase to the charges that they will be brought up against. Instead of helping them to create better lives, this bill will harm them and create a spiral where they will not be able to lead a good life and be helpful for the community because they will be stuck in a system where they are devalued and are more or less resigned to poverty-like conditions. We really need to help Nevadans and use data-protected or data-supported protections and programs in order to help make our community safer, to help make them more resilient.
And you have reached 2 minutes, so I'll need you to wrap up.
Okay. In closing, I urge you to please strongly oppose this bill as it does not help our community. It only harms it. Thank you.
Hello, Chair and committee members. For the record, my name is Mark Diefenbacher. That's MarkDiefenbacher. I'm a member of Surge Las Vegas, speaking as an individual. I'm testifying today in opposition to AB 4. No matter our race, background, or where we come from, we all want the same things: safe neighborhoods, fair treatment, and our tax dollars used to build stronger communities, not bigger prisons. AB 4 takes us in the wrong direction. Just a few years ago, Nevada passed AB 236 with bipartisan support. That reform is based on the work of the Advisory Commission on the Administration of Justice, judges, experts, and community leaders who came together to fix a system that was locking up too many people for too long, especially for nonviolent offenses. Since then, crime has gone down, Fewer people are being incarcerated unnecessarily, and the state has saved hundreds of millions of dollars. Now, AB 4 threatens to undo that progress. This bill would expand who can be labeled an habitual offender and take away incentives for people to turn their lives around. That's not justice, that's punishment for punishment's sake. It means more people trapped in a cycle of incarceration and more public money spent on prisons instead of schools, housing, or healthcare. To be clear, passing AB 4 strengthens the hand of certain politicians who rely on division, blaming new immigrants, Black communities, and people working hard to get by for the challenges we face. By creating this division, they can rewrite the rules to shift the wealth our work produces to their corporate donors who don't pay their fair share. We have a choice. We can move forward with smart justice policies that prioritize rehabilitation, accountability, and second chances, or we can go backward to a system that wastes lives and money. I urge you to reject AB 4 and stand with the people of Nevada who believe in justice, equity, and opportunity for everyone, Black, brown, and white. I do urge you to pass safety measures that promote real trust and clear rules during ICE enforcement. We need local officers and National Guard operating without masks and identifying themselves, limits on enforcement in essential community spaces, and protections for personal data sharing. Thank you.
Caller with the last three digits, 390, you are unmuted and you may begin.
Thank you. My name is Naomi Joy, Naomijoy, and I am a resident of Senate District 1 in Henderson. I urge you to vote no on AB 4. This bill is regressive and will allow for the establishment of a court for casino corporations and funnel people experiencing homelessness into the criminal system. This bill does nothing to protect those who are subject to kidnappings by ICE impersonators. So please vote no. This special session should not be in session because there is no emergency being addressed. Thank you for your time.
Yes, hello, my name is Bishop Jackson, BISHOP JACKSON. I'm in Senate District 6, and I just wanted to call to oppose this bill because the policies proposed in the bill are harmful and not evidence-backed. And on top of that, everything else that everybody else has said. Thank you.
Good evening, Chair and members of the committee. For the record, my name is Quentin Savoy. That's Quentin, S like Sam, A like Apple, V like Victor, WOIR. I have the pleasure of serving as the president of the Las Vegas branch of the NAACP. I will echo the sentiments of the leaders from our branch that you've heard precede me, but I would like to also include how dismayed we are with the continued lack of engagement. Our branch members want community safety. The median age of our branch is 68. So our branch members are not community members that are trying to give away the kitchen sink or defund the police or any of that. We are simply asking to be at the table to devise solutions that are most viable. It's really unfortunate that this bill is an omnibus bill because there are pieces of this that actually need to be broken down and to have a more tactical conversation instead of taking this broad brush approach that we know will be regressive and harmful. We urge you to do what the Assembly wasn't able to do, to vote no and stop this bill from harming our communities. Thank you for your time.
Hello, my name's Nancy Ann Leader, Nancyann, all one word, Leader, Leeder. I'm just a constituent and a voter, and I thought it might be useful for the committee to hear what a normal person, I live in Reno, what a normal person living in Reno thinks about this bill. So I thought I'd call and say the bill does not help the situation. If there is a bad situation, it doesn't help because it doesn't address causes. And it's extremely costly. And we out here are interested in what happens to our tax dollars when we have so many needs in Nevada. They seem to be increasing all the time. This bill would cost money that we should be putting in other places that help our constituents. And I have heard, while I've been listening, so many eloquent arguments against this bill that I won't go any further, just to say I was very concerned, so I've been listening. Please vote no against AB 4. Thank you.
Good evening, Chair Scheibel and members of the committee. Evelyn Grosnick, EVELYNGROSENICK. I'm the Washoe County Public Defender. I am testifying today in opposition to AB 4. Several aspects of this bill attempt to undo measures that this legislative body implemented with the passage of AB 236 in 2019, which contained evidence-based measures to improve public safety. Crime is down. Not only is AB 4 unnecessary, it will increase the prison population by creating new felony crimes, removing judicial discretion in certain circumstances, and increasing prison sentences. AB 4 is now being touted as a common sense measure to make streets safer. The implication being that increasing prison penalties and creating new felonies somehow prevents crime. Having worked directly with people accused of crimes for 12 years as a public defender, I can tell you that very few people know about or consider the penalties for crimes before they commit them. More often, crimes are committed from desperation in the heat of the moment and involve mental health and substance abuse issues. Creating new crimes and increasing penalties does not prevent future crimes. It just incarcerates more people for longer. If you want to improve public safety, stay the course on AB 236. Spend the money on resources to treat mental health and substance abuse disorders, lifting people up so that they can work and take care of their families, not locking them away. I urge you to vote no on AB 4, but if you are going to pass it, I urge you to at least adopt the Smart on Crime amendments from the public defenders. Thank you for your time.
Good evening, Chair Scheibel and members of the committee. My name is Jessica Munger, M-U-N-G-E-R, with Silver State Equality, and we strongly oppose AB 4. We stand with our partners and encourage you to reject policies that criminalize poverty and harm the most vulnerable Nevadans. Thank you.
Good evening, Chair Scheibel and members of the committee. For the record, my name is Ashley Dodson, that's ASHLEY-DODSON, with Anchor Perspectives and member representative of the NAACP Las Vegas Chapter 1111. I'm a licensed clinical social worker and policy analyst. I'm here again, now during this special session, to strongly oppose AB 4. As you all are aware, crime is now down in Nevada, has been down, yet this bill is being rushed through as political theater as elections are upon us, rather than data-driven policymaking. Removing specialty courts, our most effective tools for rehabilitation and reducing recidivism, will increase incarceration and deepen cycles of harm instead of improving public safety. AB 4 also lacks any immigration protections while expanding pathways into custody, disproportionately harming immigrant families and communities of color. The strict corridor provision effectively criminalizes homelessness by imposing penalties of 30 days to 6 months for trespassing. This does not address root causes of poverty or housing instability. It simply pushes vulnerable people deeper into the system. Additionally, the fiscal note of at least $40 million diverts resources from critical needs like treatment, housing, and mental health at a time when overdose numbers are at record highs. Finally, the previous decision to block phone testimony excluded working-class Nevadans from participating in the democratic process. Most people cannot leave their jobs or children for hours-long midday hearings, and silencing their voices was and is unacceptable. So please tell us, what do you call a real true emergency? For these reasons, I urge you to vote no on AB 4 and invest in instead proven solutions that support safety, dignity, and community well-being. Thank you for your time and attention.
Caller with the last three digits, 315, please press *6 to unmute yourself.
Good evening. My name is Andrea Rios, Andrearios. I am speaking today to oppose AB 4. I am a resident of Senate District 11. I am a veteran and I was wrongfully arrested on the strip for allegedly standing and blocking a pedestrian bridge, a ridiculous ordinance and a precursor to a regressive bill like AB 4. I was targeted because I was practicing my First Amendment rights, the same ones I fought for. I've seen others stand and block with no repercussions. My situation is not unique, and I was fortunate to have a community behind me so that I could be released in time to make it to work to provide for my family. Many are not this fortunate and are targeted for being unhoused or for the color of their skin. Even though my charges were denied, the arrest will remain on my record, and if for some reason I am stopped or targeted in the future, it could subject me to further problems. I can only imagine the repercussions this bill will cause our unhoused and our disenfranchised communities. I oppose AB 4 and strongly urge you to vote no. This bill is regressive, and the city and county will be left holding the cost for the stakeholders' attempt at pushing off protection for their property onto the community and members and taxpayers. It will, in fact, disenfranchise instead of providing resources to the community to help rather than criminalize homelessness and people of color. This bill will only overrun the already dilapidated correctional facility and does nothing to protect those who are most vulnerable in our community, including but not limited to those subject to kidnappings by ICE and our unhoused community who sometimes do hold employment, and many of which are veterans as well. Please vote no on this discriminatory bill. Thank you for your time.
Good evening. My name is Crystal Villarin, Villarin, and I strongly oppose AB 4. I speak as a UNLV student and a registered behavioral technician at an autism therapy clinic. In my work, I see how children express frustration, fear, or unmet needs through behavior, sometimes through aggressive outbursts. These are often signs of trauma, developmental differences, or emotional dysregulation, not criminal intent. AB 4 and this amendment risk turning these moments into a path to incarceration, perpetuating mass incarceration and school-to-prison pipelines. Automatic detention for any child accused for battery removes judicial discretion and criminalizes children. Many incidents are impulsive or linked to unmet emotional needs, but with proper support, children can learn coping strategies and self-regulation. This amendment also mandates mental health evaluations, allowing detention for up to 14 days while waiting. But let me be clear, screening and detention is not therapy, it is trauma. Detention disrupts school, family, stability, and treatment plans. Children in crisis need community-based support, not jail cells. Instead of helping children, AB 4 in this amendment criminalizes behavior that should be addressed with support. I urge the committee to reject AB 4 in Section 15. Thank you.
All right, can you hear me?
Yes,
Hello?
please go ahead.
All right. Hello, chair members of the committee. My name is Isaias Gallegos, ISAIASGALLEGOS, and today I'm here in staunch opposition of AB 4, as this bill will harm our most vulnerable community members by implementing outdated, ineffective, tough-on-crime policies, in addition to causing dissolution of programs that have been effective in crime prevention. This crime bill will also undo policies and progress that have been made from 2019, policies that have effectively helped decrease recidivism and crime in Nevada. This so-called crime bill uses fear and hatred to push harmful and effective policies that not just fail to reduce crime, but would instead increase crime and further harm our communities and especially our most vulnerable. We're in a time right now where immigrant families and innocent people are being picked up in the streets by masked agents. This bill will do nothing to help them. And what we need instead are policies that could solve crime at the root, such as housing inequality, for example, which is a root issue and, again, cause of crime, while also giving us, the community, a seat at the table to help draft future legislation. The Assembly locking out phone-in testimony is an example of the opposite of what we want. We want a seat at the table to help draft future legislation, as we'll be the ones most affected by bills like these. So I urge you all to vote no on AB 4. Thank you.
Hello, my name is Savannah Hodges. That's Savannah, like the city, Hodges, Hodges. I live in Senate District 2. And thank you for allowing me to speak. I moved to Nevada in April from Virginia. And when I heard there was an emergency session happening, I had hoped it would have been to deal with the Nevadans that lost their SNAP benefits in November and were given an insulting $12, as we've heard. I had hoped it would be about the Nevadans whose healthcare premiums are going up to as much as $1,000 a month, including my husband, who will now lose his health insurance while we are in the middle of a very complicated medication change that is not going well. But no. We're having a session on crime when crime is down to talk about a bill that y'all already rejected. That trafficking survivors who were traumatized, testifying not very long ago on this exact topic, showed up again and had to be re-traumatized by this legislature, by this DA, and by LFBMPD. This is a disgrace. I live in a purple state. This is not about party. Okay, this is not how you do business. We have something called the Virginia way where I'm from. You don't schedule last minute emergency sessions like this and then move around your vote times to try to dissuade public comment. It is very clear who is pulling the strings here, and it is the casinos. It is that gentleman from Caesars Management that we heard testify. And I wonder which one of these legislators are taking payment above and under the table for this. Because there is no excuse. You know there is no data for this.
All right, that is 2 minutes. I will need you to wrap up, please.
This is racism. I urge you, if you have a conscience, to vote no. If you do not, we will take notice and we will look. Thank you.
Thank you, Chair and members of the committee. My name is Amanda Cruz, AMANDA-CRUZ. I'm speaking as a community member from District 4 in strong opposition to AB 4, which is being framed as a public safety bill, when I think we've all taken recognition of the fact that it's just a contradictory mess that's going to cause real harm, in particular to our young people and the future that we're leaving for them. I think we need to recognize that the young people we are in service of are continuing to experience the trauma they experienced during the pandemic, which upended their education, their stability, and their mental health. And the behaviors we continue to see, this bill proposes to continue to criminalize. It's direct outcomes of systems that we have built, which continue to fail to support them. And instead of helping them to heal, this bill suggests we punish them for surviving what we as adults and the institutions around them failed to protect them from in the first place. And at the same time, as families across Nevada are struggling with, as you just heard, healthcare costs, housing, food, we should be building them stronger safety nets, not ripping holes in the ones that are already there for them. This bill sends a message that instead of meeting them where they're at, we will simply hit them back harder. And while corporations and billionaires continue to receive grace, second chances, pardons, and buddy-buddy shoulder rubs. Our kids are offered none. I urge you to, as a body, to remember that just months ago, Nevada's infrastructure collapsed under some random ransomware attack. We couldn't keep our own public safety systems from falling apart, and yet this bill has a whole piece in it that expands surveillance, reporting, and enforcement mechanisms that depend on digital systems we couldn't secure in the first place. If we truly care about public safety, we should be demanding transparency and enforcement by prohibiting masked officers, protecting safe zones like schools, churches, and community centers from heightened criminalization. We should be building support systems that strengthen our communities and support our families from the bottom up.
And you have reached 2 minutes. I'll need you to wrap up.
This isn't a partisan issue. It's one of morality. And I urge you to vote no on AB 4 and return this bill to the trash can it came from. We should be healing and protecting, restoring.
Chair, there are no more callers in opposition at this time.
All right, thank you so much. We will move now to testimony in the neutral position. Anybody wishing to testify in neutral in either Las Vegas or Carson City is invited forward to do so now. I do see somebody here in Carson City. Please go ahead.
Chair, members of the committee, Jonathan Norman, NORMAN with the Nevada Coalition of Legal Service Providers. We do not do criminal law, but we do criminal record sealing. And I think Chair Scheibel, you did a great synopsis of where the record sealing is in this bill and what would happen. I did want to make sure that the members know that there are, because it has child abuse, that there is in NRS 179D.0357 definition of crimes against children that are never sealable. This bill doesn't change that, so these are things that are never sealable. I feel like sometimes we can see child abuse and think it involves all crimes against children. And the other thing is when we defer, we've had a couple bills the last few sessions to make record sealing easier. Those have not been successful. I did want to point out that when we say we're going to defer to sealing under 179, NRS 179, the ordinary sealing statute, the consequences of that are 1 year. Because even with an attorney, to seal a record is going to take 8 months to 12 months. If you don't have an attorney, you're practically not going to be able to navigate that system. So when we go from automatic to 12 months with an attorney, that has consequences that I think the committee should just be aware of. And so when we're talking about that in our state, we probably have 3 attorneys who are doing criminal record sealing. And so when you think of the number of people eligible for record sealing, and you think of the capacity of 3 attorneys for that, I just think you have to weigh whether a bill, if we've decided something is sealable, should we make it harder for that thing to be sealed? And I think that's the policy decision that you're faced with in the record sealing section. And so I might have listed into some light opposition there, but I appreciate your time. Thank you.
Thank you, and I thought that was good neutral testimony providing us with information, so I appreciate it. I don't see anybody else coming forward in Carson City. I know we have someone who wanted to testify in support in Las Vegas, but we're on neutral testimony right now. I don't see anybody else coming forward in Las Vegas, so I'll go to the phones briefly for neutral testimony.
If you'd like to testify in neutral for AB 4, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in neutral at this time.
All right. Due to the fluid nature of the special session and how late it is, I want to respect everybody's time. I appreciate anybody who's been waiting to testify. So at this time, if there's anybody who wishes to testify in person who missed the opportunity in support, opposition, or neutral, I'll invite you forward now. And I don't see anybody coming forward in Carson City. Looks like we do have somebody in Las Vegas. Please go ahead, state your name for the record, and let us know what position your testimony should be recorded in, and then give your testimony of no more than 2 minutes.
Okay, my name is Al Rojas. I live in Sunrise Manor. I frequent the areas of Assembly District 21 and Senate District 2. I'm just going to change my testimony to neutral and bring some pertinent facts. I'm a member of a Neighborhood Watch program. We have 8,000 people on a Facebook page, and we've been working on the homeless problem. I've personally trespassed or been involved with trespassing over 45 people. And how many people have gotten arrested? 0. Because the trespassing laws give you the option to leave when you're asked to leave. It's protected our businesses that are out there for people who need to get these homeless people off of our area. And we are working with supportive services like Shine a Light and other outreach programs. So most of these laws that are out there are for preventative, okay? There are restorative measures that are involved, okay? And there's very few people who get locked up and the key get thrown away to say. I just even went this weekend with Bolden Command Area, and we asked them about what happens when you arrest some of these trespassers, and they're usually out in less than 4 hours. So we are just trying to protect our small businesses is what's going on. And in closing, there's an article that I just read on Review Journal that says that from January the 1st to October the 9th, the Metropolitan Police Department has received 5,941 reports of shoplifting, which is considered a form of larceny, which is an increase of 12% from the same period last year. So it depends on where you look at it. There are some areas that are crime has been increasing, but generally speaking, I find that the policies, especially down in the corridor, are more of a preventative measure than going in there and arresting people. For Metro, if Metro wanted to arrest everybody, we could arrest everybody in a half hour and fill up all the jails. They are taking a preventative measure, and so is our judge. You know, you have to go through a judge, and we are working closely with our restorative services.
And that is 2 minutes, so I'll need you to wrap up.
Thank you very much. I'm done. Thank you.
Thank you.
Good afternoon. My name is Imer Cespedes, and I would like to share my public comment against this bill.
We're on testimony right now on AB4. If you would like to testify, go ahead. If you'd like to give public comment, that's coming later.
Okay, so I would just like to testify against the AB4. My name is Imer Cespedes for the record. Thank you.
All right. Thank you so much for joining us. I don't see anybody else coming forward to give in-person testimony in any position. We will do the same thing for the phones. Is there anybody on the phone line who did not get a chance to testify on AB4?
If you would like to testify in support on AB4, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in support. Would you like to proceed into opposition?
Yes, please.
If you'd like to testify in opposition on AB4, please press star 9 on your phone to take your place in the queue.
Hello, can you hear me?
Yes, please go ahead.
Okay, my name is Kathy, and I am going to be opposed to this bill because I want to say that why is Nevada not finding solutions for these problems, especially for the homeless? It's only going to get worse, and we have to be forward thinking on this, especially with the administration that's in office. There'll be more crime if we don't find solutions. So thank you. So I am against this bill.
Chair, there are no more callers in opposition. Would you like to proceed to neutral?
Yes, please.
If you'd like to testify in neutral on AB4, please press star 9 on your phone to take your place in the queue. Chair, there are no callers in neutral.
All right, thank you so much. At this time, I will close testimony on AB4. I understand that our presenters do not need to make any closing remarks, so that concludes our hearing on AB4. Thank you, everybody, for your patience, your time, and your participation. We really do appreciate folks coming in to voice their opinions on this important piece of legislation. Now that the hearing is closed, we will move to public comment. Public comment is an opportunity to talk about something within the jurisdiction of the Public Safety and Security Committee outside of the bills that we have heard. So it looks like we have someone here in person to give public comment in Carson City. Please go ahead whenever you're ready.
Thank you, Madam Chair, members of the committee. My public comment is on the bill you just heard on AB4. Is that permissible, Madam Chair?
I am so sorry.
Just wanted to check before you.
But please submit your testimony in writing.
Thank you, Madam Chair.
Thank you. All right, I don't see anybody else coming forward to give public comment, so we will go to the phones for any public comment.
To participate in public comment, please press star 9 on your phone to take your place in the queue. Chair, the public line is open and working. However, there are no callers at this time.
All right, then we are going to go into a recess at this time. And again, thank you all for your participation. We're in recess.